always wanted to serve on a jury.
I'm really super excited to be here, so I really appreciate you having me. I'm looking forward to it.
I want to give a big shout out to the 13th Jury Podcast and Brandi.
Yeah, I applaud you guys. Keep doing what you're doing.
And then I just look to the jury, and it's sort of like, look.
Hey, if you're bored of work, come pop in and say, hey, want some coffee?
You are a ray of sunshine, and I love what you've done with your YouTube channel.
Good morning. Good morning. Hello. Hello. Welcome. Welcome. I'm all bundled up in my big jacket. I just got in from taking Lucy out, and I just looked at the camera for the first time and realized I look like an Eskimo. It's cold here today. Hello. Good morning. I am about to pull up a couple different feeds. I have the actual Zoom link for the hearing today, and then also I believe there's going to be I think they're having a feed on like one of the live feeds too, like the inside the court. So I've got both pulled up just to check. It is cold outside. Good morning. It is good to see y'all too. Linda says, love that jacket. You know, I got this jacket at Cracker Barrel, of all places. It has like that soft stuff. Do folks in Florida have any heat sources for when the weather's cold? My heat sources are this jacket and Lucy. That's pretty much it. I don't think I've ever actually turned on the heat here, because even when it gets really cold, all I do is just shut my window. Get a blanket. All right. We have a lot going on today, y'all. So we have I'm still waking up. I'm extremely tired. So forgive me because my mind's going to be a little bit scattered. We have the Karen Reed hearing this morning. They are already, let me pull up and show y'all kind of what's going on out there while we're watching. I was looking over some of the recent court filings to watch and see what all's going on. But all the stuff that they filed, you know, obviously I've had a lot going on lately, so I haven't been able to do the next episode of the podcast. Like, I've got documents everywhere. My whole screen is covered in documents. Okay, let's see. Court TV is showing it today. I've also got this, I think Court TV is showing it today. I've also got the Zoom. It's ready to go when it gets started. And then you can see, look, these are all my documents that I was reading over. I got stuff everywhere. All right, but I wanted to show you all this. There's people already there. And, you know, I've showed y'all before that this is one of those that is like, people get angry, y'all. People get so angry. There's a lot of mute. There's a lot of people involved in this one who are, you can see, let's see. Let me start this over. You can see all the people out there that are They've got their signs. Protesting. I saw a truck earlier that drove by. They rented one of the trucks that drives by with like the big billboard thing on it that said "Free Karen Reed." Hold on, let me pause some of this. This is from Facebook. Okay, so you can see some of these signs too. Like for example, the "How long for justice," but it's spelled HOS. Of course, that's based on, for those of you who haven't listened to the podcast or haven't been following this, the reason all this is misspelled is because there's a Google search that was done for "How long to die in the cold" by Jen McCabe at 2:27 a.m. from inside the house where John O'Keefe's body was found outside. That's been one of the biggest points of contention because people are obviously going to question, why would she be Googling that? Why would she be searching for that if nobody knew that his body was out there yet? So, so you'll see a lot of this, the HOS, it was misspelled in the search, and that's why. But you'll see a lot of that. You see the Free Karen Reed signs, and let's see what that one says. Obvious dog bites. That's one of the things too. The autopsy that was done, the injuries that John O'Keefe sustained, I'm no medical expert. To me, it doesn't look like he got hit by a car, especially since there was no real damage done to the car except for the whole taillight shenanigans. But I'm no medical expert. But a lot of people are looking at those injuries like that's not consistent with, being hit by a car. And one of the theories is that it's dog bites. They had a German Shepherd. The family in the house where he was found had a German Shepherd, of course, named Chloe. Had this German Shepherd for years and years. And then not long after this happened, then the German Shepherd was gone. Obviously, that doesn't make sense. People don't just give away their dogs that they've had as part of the family for 7 years. So that has fueled that theory as well, that that it was some kind of fight that broke out in the house, maybe drunken scruffle gone wrong, whatever. And if there's a fight going on and a dog sees their owner in a fight, especially, German Shepherds, I had a German Shepherd. They're very protective. So one of the theories is that that the defense has said is that, if there was a fight in the house, Chloe, the German Shepherd, saw the fight happening. And then, of course, like any dog would, jumped into, thinking that her owner was in trouble or whatever. So that's that's kind of where those come from. So I only wanted to explain the signs for y'all because I know some people have kind of joined us since I've been dealing with health issues again and haven't been able to do the podcast episodes the last couple months. So I know some of y'all are not quite as up to date on all of this, but that's what those signs are. So, but these are all the people at the courthouse this morning. This was posted on the Facebook group. And then "We ain't got no quit." There was, I have a clip of that in one of my podcasts too, where Karen Reed's attorney was on the, I was about to say porch steps. God, y'all could tell where I'm thinking about back home. Not porch steps, the courthouse steps. And he, was given, let me move all my documents. He was given like a, statement to the public or whatever. And that's one of the things he said is, "We ain't got no quit." So that's what that's from. All right, let's listen to this.
This is very divided. As you know, there are factions of people in the Boston area who believe she did this murder, and then there are factions who believe that she was framed for it. We're going to go live to that hearing next.
So this has been one of those things that has been like dividing people. People on Twitter hate each other. It's almost, it's the worst I've seen aside from probably, I won't even say aside from Murdoch, it's about the same as Murdoch, where people just freaking hate each other, like going after each other, starting fights. It gets really exhausting. I have, obviously, anybody who's listened to my podcast, I have a lot of questions, and I am not a conspiracy theorist type. I am the math needs to be math and type. I am one that I want to have answers. I want to understand things, and a lot of the stuff that has come up on this, pull up another feed real quick. A lot of stuff that has come up on this does not make sense. It doesn't make sense. And I have a lot of questions. And let me get this. Okay. And so I've asked a lot of those questions. This is expected to be pretty explosive. Because every single time they meet, it's pretty explosive. If y'all watched the last one with me, it was the first time I've ever in my whole entire life, seen any kind of court hearing where people like applauded, and we watched it, and it was the craziest thing, because no matter what you think happened, John O'Keefe deserves justice. And if that justice is, if that justice ends up being, let me start over. He deserves justice, which means whoever is responsible for the horrible death that he suffered should be punished. If you believe that person is Karen Reed, cool. If you believe that person or people are the Alberts and McCabe's, cool. If you believe it's anybody else under the sun, cool. I don't give two shits who you think is responsible. My biggest issue with it is that he deserves justice, and you cannot have justice if you have a dirty prosecution, a shitty investigation, lies in your reports, obvious issues with, let me mute. Hold on. Okay. Oh, Beverly. Oh. Hide on video. You can see her right here. They're applauding her coming in.
Oh boy, did you hear that? Cheering in the court.
So, hold on. Let me change my. This should be starting in 1 second. Hold on.
For more on the background of this case, here's Court TV legal.
Why are they still doing background? Why is mine not on? What is happening with my feed? What the heck is happening with my stuff? Hold on.
It's directed to Jennifer McCabe, Trooper Michael Proctor, and Elizabeth Proctor. Who's arguing that for the defense? All right, I'll hear you, Mr. Jackson.
Free my boy Billy Tibbetts. Free Billy in the trap.
Kevin, could you just be either mute or watch us?
Jim, that's not me. It's somebody else is saying free my boy Billy Tibbetts. That's not me.
Okay. Thanks, Mr. Reddington.
Thanks.
Go ahead, Mr. Jackson.
Kevin, that was you.
Good morning, Your Honor, and thank you for giving us the time to address the court on these summonses for the third-party communications. I think I can cut this relatively short, given the Commonwealth's position that they are in agreement that the summonses for these third-party communications should issue. I want to save some court time.
Billy's innocent.
All right, so we may have to cancel Zoom for everybody if this keeps up. We will have to cancel Zoom for everybody if this keeps up.
I think I got that person, but
Fuck off, Beverly.
I didn't.
Go ahead, Mr. Jackson.
Thank you, Your Honor. I want to try to save some court time and judicial resources. If the court is inclined, given the Commonwealth's position that they are in agreement with us to issue the summonses, I'll just submit on the papers and be done.
I have third parties that need to be heard.
If the court wishes, I'm happy to address the third party concerns once they are heard.
No, I'll hear you now.
In terms of the papers that were filed, and my understanding is Mr. Reddington joined on Ms. McCabe's behalf with Elizabeth Proctor's motion and her position filed by her counsel. It basically comes down to a singular issue, and that is one of privacy. They don't have standing to argue Lampron. They're not parties to this action. It appears the Commonwealth, who is the party to the action, has agreed that Lampron, the elements of Lampron have been met with our request insofar as it is concerned, specifically and addressed to Michael Proctor, Trooper Michael Proctor, and his communications with Jennifer McCabe, Elizabeth Proctor's communications with Jennifer McCabe, Jennifer McCabe's communications, counter communications with Elizabeth Proctor, and Michael Proctor's communications with Brian Albert and Nicole Albert. I'll address the issues that counsel raised in his moving papers on behalf of Elizabeth Proctor, because that's the only writing that I have to go on at this point. He basically argued that there are false statements made about Michael Proctor's relationship with some of these other parties. Since the very beginning, and that brings up the fundamental issue, Your Honor, of what is that relationship and what's the nature of the relationship, and why do we believe that that relationship establishes extrinsic evidence of bias and an inability to be neutral.
They're going to end this.
From the very beginning of this case, we have questioned the neutrality and the bias of Michael Proctor and certain other government witnesses based on overwhelming facts that we've learned, overwhelming facts that establish that both this investigator and this investigation are compromised. That's why we...
Do you have that, Tori? Okay. Go ahead.
Thank you. That's why we've asked for the communications that the Commonwealth has now agreed with. Our request is nothing short of critical to our defense, obviously, and it's based on Ms. Reed's constitutional right, as established in Davis versus Alaska, the U.S. Supreme Court constitutional right, that's recognized as the right to attack the credibility of any government witness, be they a government witness on behalf of the police and the investigation or any other government witness.
Is Elizabeth Proctor a government witness?
She is not, but Jennifer McCabe is. And the communications that we're interested in are the communications that are concomitant between Elizabeth Proctor and Jennifer McCabe. We've established that there is a close personal relationship between and among Michael Proctor and obviously Elizabeth Proctor and these third-party culprits that have been implicated in this case that we've brought to the court's attention, the Alberts and the McCabes. That's the relationship, and that's the foundation of our request. This is so important that I'll bring it back to the court's attention, and the court knows this, that even the sitting DA, the elected DA, decided to weigh in on this issue of the relationship between the Proctors and the McCabes and or the Alberts. And he said there's no such relationship, zero. This doesn't exist. As a matter of fact, the word that he used was, it's a lie. Any suggestion to the contrary that there's any kind of relationship between the Proctors and the McCabes or the Proctors and the Alberts is a lie. His words. So the DA himself has put Trooper Proctor's neutrality at issue, and he did it in the most public way possible, and I would suggest a clumsy way. Who was he talking to? He didn't come into this courthouse and address the court, as we've all done. He didn't address the court. He didn't address the Commonwealth. He is the Commonwealth. He didn't address us, the defense. What he did do is he addressed the public and the potential jurors, and that was by design. So he calls the evidence that we've procured and that we've presented to the court as lies. Well, let's look at those lies for a quick second. We have presented the court with photographic evidence, not something that we came up with, something they came up with. Photographs in Exhibit C in our moving papers. And I'll just cover a couple of those. There's a photograph that we presented that shows Trooper Proctor's mother, the person by the name of Colin Albert, pictured in the photograph, with Trooper Proctor's sister pictured in the photograph, with Chris Albert pictured in the photograph, and with Jennifer McCabe's own daughter depicted in the photograph. They're all together at a birthday party. These are close and immediate family members of the Proctor family, the Albert family, and the McCabe family, and they're all together and they're socializing. That's not a lie. It's a photograph.
Yes.
And it's unassailable evidence of that relationship. There's a second photograph of Trooper Proctor and Colin Albert in a wedding party together. And I would urge the court to note, they're not at a wedding together. They're in a wedding together, in the wedding party. There's a third photograph.
And when was that? When was that? When was that?
2012. So this relationship, as the court just noted, and I was about to get to in a second, is not just days old, months old, weeks old. This relationship is decades old between these families. There's another photograph that the court has seen, Trooper Proctor literally on the dance floor with Colin Albert. So when counsel for Elizabeth Proctor suggests, oh no, these relationships, you can't believe any of this stuff, just because someone happens to be at the same event does not thereby establish a relationship. They weren't just at the same event. They're in a wedding party together. They're standing on the dance floor, side by side, shoulder to shoulder, Trooper Proctor and Colin Albert. And then we see a photograph of all of them seated at the same dining room table. They shared a meal together. This is socializing. These are interpersonal relationships, and they can't change that. Trooper Proctor was seated at the same table, having dinner with Colin Albert, Chris Albert, and Chris Albert's wife, Julie. Then there's the Facebook post, and I will leave it at this. I'm not going to go through the entirety of my motion, but I would highlight the last point that I think should be highlighted for the court's attention, and that's the Facebook post. Trooper Proctor's mother refers to the Albert family as the Proctor's second family.
That's in one of the posts.
So one might actually ask Mr. Morrissey, who's actually lying in this case? Is it us? We just presented the court with factual information that was procured off of social media that it's unassailable. It cannot be assailed. And the Proctors have known these people for, as the court just mentioned, by asking for that date, for more than a decade. They've socialized with him, and his family considers their family to be so close and interconnected that they are deemed a second family to the Proctors. And who exactly are members of this Albert family and or McCabe family? Let's look at those members. Brian Albert, Nicole Albert, who is Jennifer McCabe's sister, Brian Albert Jr., Brian and Nicole's son, Caitlin Albert, Brian and Nicole's daughter, Jennifer McCabe, Nicole Albert's sister, Matt McCabe, Brian Albert's brother-in-law, Chris Albert, Brian Albert's brother, Julie Albert, Brian Albert's sister-in-law, and Colin Albert, Chris and Julie Albert's son. The McCabes and Alberts ostensibly are one family. They socialize within the same social circle and the same familial circle, and that is who the Proctors have proclaimed to be their second family. And if that weren't enough, we find out during the pendency of this case on September 25th, 2023, that one of those family members, Jennifer McCabe, who's the subject of great interest in this case and a primary person of interest in this case, is invited to Trooper Proctor's personal home for some sort of off-the-books meeting. Do we know about this meeting? Because Trooper Proctor, upon learning this, that Jennifer McCabe was coming to his house, ran back to the office and filed a police report, a supplemental report explaining this meeting, this off-the-books meeting. No, he never disclosed it. We found out about this because a concerned citizen happened to photograph Jennifer McCabe's car parked outside Michael and Elizabeth Proctor's personal residence in the evening after hours. And the best that counsel for Elizabeth Proctor can muster in terms of an argument is to say, well, you know what, Your Honor, maybe he wasn't home. Maybe, or maybe not. The suspicious part is Trooper Proctor isn't saying, and there's nothing in Elizabeth Proctor's motion to suggest that he wasn't home. Certainly his car was there. Elizabeth Proctor's car was there, and Jennifer McCabe's car was there. Was Trooper Proctor home? I guess I would answer that by asking the question, does it matter if Trooper Proctor was home? They've now admitted that Jennifer McCabe, a central character in the middle of this investigation, in the middle of this crime, was secretly meeting and or socializing with the lead investigator and or his wife in the living room of their home. And that, Your Honor, is a problem.
That's a huge problem.
And it shows more than a professional connection. It shows a personal connection. And according to the Proctor family's own counsel, Elizabeth Proctor's counsel, the subject matter of that meeting was commiserating about this case. They weren't talking about sports. They weren't talking about the weather. They were meeting about this case. So how does that not show a bias, and how does that not implicate Karen Reed's constitutional rights to this information? And to this day, the Commonwealth has yet to concede what obviously is now sort of front page news, that there is in fact a personal relationship between the Proctors and their second family, the Albert McCabe family. But here's what the Commonwealth has said, even though they haven't made that connection or that concession. On October 3rd, 2022, Mr. Lally made a couple of points, eloquent points in this courtroom. And what he was doing when he did it in October was illustrating what an inappropriate relationship would look like if one existed, what a conflict of interest would look like if one existed. And he said, quote, Michael Proctor has been fully vetted, end quote. He said, there's no conflict of interest here because it's not like, quote, these people are socializing together, end quote. He said, it's not like, quote, these people know each other, end quote. And he went on to say, it's not like, quote, these are people that Trooper Proctor has been over to their home, end quote. The Commonwealth said that because these facts would surely illustrate a conflict of interest. They would surely illustrate an undeniable bias. And those comments, Your Honor, I would suggest have not aged well. And I would wonder at this point if the Commonwealth hasn't adjusted its stance, which is why the Commonwealth is now conceding that we're entitled to these communications. And that turns on the question of asking, how could Trooper Proctor be expected to adequately and honestly investigate this case as the lead investigator, and also investigate the Albert McCabe involvement in this case, with this history of an interpersonal relationship and allegiance to those very people, the very third-party culprits, the very people who should be suspects in John O'Keefe's murder? And the answer is he cannot. And since the authorities, including Michael Morrissey, apparently have vouched for Trooper Proctor, my client, our client, Ms. Reed, is entitled to question and to test that voucher. And that's what we're seeking to do with the communications between Elizabeth Proctor and Jennifer McCabe. And insofar as that request is concerned, it's unquestionable that there are privacy interests at play, but I would suggest the following: that the constitutional due process rights of any criminal defendant in any criminal case hold a paramount significance because they form the very backbone of the justice system that this court presides over. And protecting those rights, such as the right to a fair trial, such as Ms. Reed's right to the presumption of innocence, that ensures an equitable trial and an equitable process. And while privacy rights of Elizabeth Proctor, a third-party witness, are obviously an element of concern and consideration for the court, they must yield to the imperative of a fair trial. And that imperative means Ms. Reed's ability to confront and properly cross-examine all witnesses, including Jennifer McCabe, including attacking the credibility of government witnesses, including Jennifer McCabe, based on bias, and that is fundamental to our justice system. So striking this balance ultimately upholds the integrity of the very system that this court is making sure exists and continues throughout the process of this trial. Elizabeth Proctor's privacy rights, while they exist, especially in light of the narrow focus of our request, are vastly outweighed by our client's right to a fair trial. And with that, Your Honor, I'll submit.
All right, thank you. Mr. Lally, are we going to hear first from counsel for Ms. Proctor, counsel for Ms. McCabe? I got an appearance this morning of counsel for the troopers as well. Counsel for the troopers going to address us?
No, Your Honor, that's in reference to another motion.
Okay, so I will hear counsel for Ms. Proctor.
So Ms. Proctor is the wife of the lead investigator who
Thank you, Your Honor. Good morning.
Good morning.
Andrew Kettlewell for Elizabeth Proctor.
Good morning, Mr. Kettlewell.
So
one of the main witnesses.
this is not a balancing test between the defendant's right to a fair trial, which is obviously constitutionally protected and paramount to our system, and Elizabeth Proctor's privacy rights. This is a request to bring evidence before this court for the purpose of trial under the mechanism of Rule 17 that is not within the framework of Rule 17. And I'm sure the court has had the opportunity to review our papers. Our sole basis of an objection is not Ms. Proctor's privacy rights. That is obviously a paramount concern to any third party. And the interest in not being harassed or brought into a criminal matter or a civil matter that that individual has no involvement in is obviously of interest to anyone. But as it relates to the standard here, the question is whether the defendant's request satisfies the 4 prongs of Lampron and the basis of Rule 17. And the defendant's request, I would submit to the court, fails on 3 of those 4 prongs. And I'm not going to belabor the facts underlying this whole situation. My brother laid out his case. That is laid out quite clearly in his affidavit as well. What I would say about the facts is, with regard to the first prong of admissibility and relevance, while hearsay that is reliable is certainly sufficient as a basis for a subpoena to issue, hearsay which is not a basis for a subpoena to issue. And in this case, my brother's affidavit essentially amounts to a large collection of conjecture and allegations which are not supported. With regard to the motion and the opposition that I filed, I appended an affidavit that lays out the basis for why I assert what I assert in my affidavit. And that's essentially conversations with individuals who have personal knowledge of where Michael Proctor was on the night of September 25th, 2023, individuals who have personal knowledge of the connections between, as my brother says, these two families, and who have personal knowledge relating to the actual photograph that my brother didn't mention in Exhibit C of his affidavit of Michael Proctor with two children who are still minors, who are not children of Jennifer McCabe. Essentially, the relationship between these two, quote, families is a distant connection that involves 5 separate steps of relationships between, I guess I'll call them relatives. Mr. Proctor's sister has a friend whose sister is married into the Albert family. And that's Chris Albert, not Brian Albert. And so what brought these different families to a wedding in 2012 was the fact that Mr. Proctor's sister, or Elizabeth Proctor's sister-in-law, was getting married, had her friend at her wedding, and her friend's sister and her family also wound up attending that wedding. The fact that Colin Albert and Michael Proctor were in the same wedding party, I think, is mitigated somewhat by the fact that Colin Albert was about 10 years old at the time and served as a ring bearer because he was a child. So the connections that my brother tries to lay out in his affidavit, I would suggest, are not what that affidavit makes it seem. Regardless of all of that, there's still issues on admissibility and relevance under the first prong of Lampron. And the reason for that is the defense actually includes a description of this September 25th meeting between Elizabeth Proctor and Jennifer McCabe and why that meeting occurred in a state police report that it actually appends to its motion. And whether or not a court down the road agrees that that area of testimony is valid grounds for exploration for impeachment of Ms. McCabe, what's occurring here is that the defense is attempting to use that as a basis to go get another layer of even more extrinsic evidence on the hope that something that's in the phone of an unrelated third party might impeach Ms. McCabe in an area that is already potentially a grounds of extrinsic evidence for impeachment. And that is not what is permitted under Rule 17. That is a hope, that is a conjecture, and that is not the purpose of the rule. And I am not going to belabor the point for the court because I know the court is very familiar with Rule 17, but the purpose of the rule is to bring into the court for inspection and for purposes of trial records which are going to be admitted or are likely to be admitted at trial. It is not for discovery. It is not for exploration, whether or not that exploration the defense believes is part of its case or not. It's a question of, are those records going to be admitted at trial, and do we know they exist? And the defendant hasn't made out any of those factors at this point. The defendant is essentially assuming that there are records, does not know what is in those records, and as a basis is requesting. And that is not a Rule 17 motion, that's a discovery motion. And with regard to that kind of last prong of Lampron, I think the defendant makes clear her basis for the request in counsel's affidavit, as I cite in my opposition. And that's thus the communication surrounding this, parentheses, and other meetings, which again, the defendant has no basis to believe there might even be other meetings, close parentheses, may reveal information necessitating further pretrial motions, including a motion to dismiss based on extraordinary governmental misconduct. And that's the purpose of this Rule 17 motion, but that's not the purpose of Rule 17. The purpose of Rule 17 is to bring into court relevant and admissible records. These records are not relevant to an issue in this case. They would not be admissible under any rule of evidence. And based on what's actually asserted by my brother in his affidavit, nothing about that assertion meets the rule of Rule 17, meets the requirements of Rule 17. The fact that communications may reveal information right off the bat fails. And the fact that they are looking for these records as they might necessitate further pretrial motions, including a motion to dismiss, is entirely anathema to Rule 17, which is designed to bring records into the court for purpose of trial. And so based on all of those and what I lay out in my papers, I would ask the court to deny the motion.
All right. Thank you very much. Mr. Reddington, do you want to add anything? I do have your motion to join in the opposition that was just argued by Mr. Kettlewell, but do you want to add anything to that, sir?
No, Your Honor. What I would do is basically, as I indicated in the motion, is join in on the motion, noting the objection of Jennifer McCabe, obviously asserting her privacy rights, obviously suggesting, as counsel just did, that this is a clever maneuver to try to kind of weaponize Rule 17 to turn it into a discovery motion. We all know that the September 25 meeting was about harassment and what these two women had been going through on the news media with the extreme harassment that they were suffering as a result of their being witnesses on a case and cooperating with the government's prosecution of Ms. Reed. So I suggest to the court that comments like the records may reveal, and they possibly would show, which is what's in the motions that's before the court, clearly shows that there's no basis, there's no factual basis to determine that these are relevant material records other than speculating that they may reveal. Just like the allegations that the photograph of the two young kids would be Jennifer McCabe's daughters, and they're not. And it's so frustrating to the McCabe's and everybody else because they know whose kids these are. The parents know that they're their children, but nevertheless, they consistently suggest that this is showing that he's sitting there with these two kids that are the McCabe's children, and therefore, as counsel argues, this is evidence of extraordinary governmental misconduct, which is a wild accusation to be making at this point. And I suggest to the court that weaponizing Rule 17 is not proper. I join in the government's request initially objecting. And the fact that counsel has indicated that the government basically concedes and assents and does not oppose should not interfere with Your Honor's analysis of Rule 17 as opposed to any Rule 14 or any discovery motions that would be appropriate before the court. Thank you.
All right. Thank you very much. Do you want to respond, Mr. Jackson, before I hear briefly from the Commonwealth?
Very, very briefly. Your Honor, I would simply, to the microphone, I would simply note as to my brother's arguments, eloquent as they may be, they missed the mark. Obviously, this is relevant and admissible. Again, I don't believe that Elizabeth Proctor has standing in the court to actually argue Lampron, but since it was brought up and since that seems to be the foundation of her argument, I do want to address one point. There's a case that was cited by my brother in his moving papers called U.S. versus Abel. It's found at 469 U.S. 45. It's a 1984 case. It does not stand for the proposition that is propounded in the paperwork. Indeed, that is a federal case, not a state court case. That's the first line of distinction. Second of all, it is a mischaracterization of the holding in Abel to say that the scope of impeachment is the outer limits. The scope of impeachment is limited to the outer limits of taking the witness's word for it. And I would simply bear upon or ask the court to review the actual holding in Abel. Justice Rehnquist does not state that the scope of impeachment is limited to, quote, taking the witness at the witness's word or taking the answer of the witness, end quote. But rather the court specifically held that it's permissible to impeach a witness by showing his or her bias. And that's all we're seeking to do. In the court's words, Justice Rinkwist's words, quote, a successful showing of bias on the part of a witness would have a tendency to make the facts to which the witness testifies less probable in the eyes of the jury than it would be without such testimony. And that's found at page 51. Contrary to counsel's misunderstanding of the holding of Abel, our impeachment of this witness is not limited to taking Jennifer McCabe's word for it. We're entitled to extrinsic evidence about her bias, about her lack of neutrality, about her attacking her credibility. This evidence is clearly relevant, it's clearly admissible, and the Commonwealth concedes as much in its opposition paperwork. And with that, I'll submit.
Mr. Kettlewell, did you need to respond in any way? Okay, sure.
So I'm not going to debate Abel because the court can certainly read the case. But essentially, it's the defendant's burden to meet Lampron. The defendant bears the burden to get the court to issue a subpoena and has to show all four of those factors. And it's not about whether the Commonwealth objects or does not object, and whether I have standing beyond an issue of privacy or not, which I would argue that a third party whose records are being sought certainly does. It's a question of whether they have met those elements, and they have not.
All right. Mr. Reddington, did you need to add anything to that?
No, Your Honor, I'm good. Thank you.
Okay. All right. Does the Commonwealth want to argue this in any way?
Just briefly, Your Honor.
Okay.
Not a fan of him.
Thank you, Your Honor. Not to belabor the point, but just to make the Commonwealth's position clear, the Commonwealth is not opposing. The Commonwealth, however, does not assent, does not concede anything as it relates to any sort of relationship or whatever is being termed as a close personal relationship. The relationship, as the Commonwealth understands it, between essentially Trooper Proctor and Ms. McCabe is that Trooper Proctor has a sister who has a friend who has a sister who has a husband who has a brother who has a wife who has a sister who is Jennifer McCabe. And it's such a close personal relationship that after apparently scouring social media, there are exactly 0 photos the council has produced of Ms. McCabe and Trooper Proctor pictured together at any point in time. And essentially what you have to establish this close personal relationship is a wedding party from a decade ago and some photographs of Trooper Proctor with children purported to be Ms. McCabe's children, which are not Ms. McCabe's children. But given the limited scope of what is being asked for, the Commonwealth is not opposing the motion, but would obviously request that if the court were to allow the motion, that both sides would have equal access to inspect and copy whatever screenshots are then provided by the record holders, that being the third-party witnesses. Thank you.
All right. I'll take this under advisement. Mr. Reddington, you're free to leave, but thank you for attending. You're free to stay too, but all right. So now we'll do the motion regarding the Commonwealth's motion for protective order pertaining to the DNA profiles of the investigating law enforcement officers. So I'll hear from the Commonwealth first, then I will hear from counsel for the officers, and then I'll hear the defendant's opposition. Who's arguing this for the defense?
I will be, Your Honor.
Okay. All right. I will hear you, Mr. Lally.
She denies everything.
So, Your Honor, just to clarify on this, just a point I think maybe misconstrued based on the defendant's opposition. This is not a situation in which these troopers have consented to anything at this point. The purpose of filing the motion was to try to gain some guidance from the court as to how mechanisms would be concerned with the collection of DNA, the retention of DNA, the destruction of DNA, and the timing in regard to that prior to obtaining either Trooper Proctor or Sergeant Buchanan's consent in relation to the taking of any bugle swab. So how this sort of arises is there is a DNA report in relation to the taillight of the defendant's vehicle. There are 3 possible contributors to that DNA mixture. One is positively identified as that of the victim, John O'Keefe. 2 others are unknown. There's been rampant sort of speculation, accusations levied against these particular troopers in regard to contaminating evidence or planting evidence and things of that nature. So the exploration of this is sort of caused by that, in the sense of the Commonwealth believes that whatever DNA comes back, it would exclude those 2 troopers as being contributors to the unknown sources of DNA. So what the Commonwealth is seeking, and the reason that the Commonwealth actually filed another motion asking for sort of an expedited response from the defendant, is the hope of the Commonwealth, especially with March 12th jury trial date looming, was my hope was that there would be some sort of agreement that could be come to and a joint proposal to be presented to the court, so the court could act on the papers, and this testing could be well underway, if not already completed, by the time that we reached today's court date. That unfortunately was not what happened. So we received the response earlier this week from the defendant. Essentially, most of the proposals that are included within the defendant's opposition are the precise alternative proposals as far as the protocol as the Commonwealth had laid it out. So as far as the defense not wishing for anybody associated with the state lab or state police to be collecting the sample, that's fine. We had proposed Ms. Christina Owens simply because she's a civilian member of the crime scene services section. But if it, as long as it's a certified collector, it doesn't have to be anybody associated with that. The defendant has some issue with the state police crime lab conducting any of the testing, whether that be generating the sample or doing the comparative testing, and seems to be fine with that process proceeding at Bodie and Lorton, Virginia, where some other testing related to this case is already being done. That's fine with the Commonwealth as well. Obviously, that's going to prolong things a little bit, I would submit.
Do we know that?
I mean, what I can say is that our office would certainly be inclined to pay whatever additional fees would be necessary to expedite that testing. But as far as the time frame is concerned, I really can't say exactly how long that's going to transpire for. But as far as it seems to be sort of the main sort of point of contention is the defendant's ability or access to the actual sample. That is something I would object to. As far as, particularly in this case, I don't think there's really going to be any question that the samples or the profile that's generated is the profile of the individual troopers. It's going to be collected by an independent certified collector. It's going to be the DNA profile will be generated at an independent lab. The comparative analysis will be generated at an independent lab, and counsel would certainly have access to those DNA profiles should the defendant wish to compare it to any other types of any other pieces of evidence or any other DNA that either they recovered during their evidence inspection or that was collected by the state police in regard to their investigation. So the need for the actual sample, I'm not really sure where that comes from, and the suggestion that the Commonwealth would have more access to it than the defendant would, especially if the court is inclined to go with the alternative suggestions of the independent collector, the independent generation of the profile, and the independent comparative analysis. I really don't see what defendant's access to the samples does or lends to any sort of credulity to the testing or to any further testing that the defendant wishes to conduct. So as far as that, I think really the only other sort of disparity or sticking point is the retention. The Commonwealth had suggested the end of the trial process. The reason for that versus what the defendant is suggesting as far as the conclusion of the appellate process is obviously the close of the trial process has a much more definitive end frame to it, as opposed to the appellate process that could go on for months and years, if not after. And given the limited nature for which the Commonwealth is seeking the consent of these troopers to conduct this DNA analysis, it certainly made more sense to myself and to the Commonwealth as far as setting that time period. If the court wishes to alter that to the conclusion of the appellate process, there are other mechanisms I would suggest that the defendants, could avail themselves of should they have a need for. Again, the profile would exist, sort of in perpetuity in their possession, at least until the end of the appellate process. And there are obviously far more mechanisms available today than there have been in previous years as to post-conviction discovery and obtaining further samples, things of that nature. So again, that was the reason for the suggestion for the end of the trial court process. But again, purpose of this motion was to seek the court's guidance as to exactly what the parameters of that collection, retention, destruction, and all of that would be, so that can be presented to the troopers so that they can make an intelligent decision as far as their consent is concerned.
If this were ordered to be done at the state lab, when would the results be in?
That, I think, especially given just prior turnaround time in relation to other testing that's been done in this case, at the state lab, I would hope that could be completed within 6-7 weeks, something like that, at the most.
Okay. Do you want me to hear from Ms. Lundgren now or after? I mean, this is your motion. Do you want me to hear from her now?
I think that's fine as far as the order's concerned.
Okay.
They did ask for the judge to recuse herself, and she denied it. She's like, no, I'm good. I'll just stay right here. Keep denying every motion you make.
Gretchen Lundgren, Your Honor.
Good morning.
Good morning, Your Honor. Thank you for hearing from me on behalf of Sergeant Buchanan and Trooper Proctor in a discussion as their privacy interests as it relates to the Commonwealth's motion for a protective order. The proposed protective order strikes a balance between protecting the sensitive and personal DNA information of two individuals who are not alleged to have had anything to do with the death of John O'Keefe, while giving all parties access to the resulting scientific DNA analysis. The defense's opposition casts the proposed protective order as allowing the Commonwealth to obtain, test, and analyze the samples without giving them the same opportunity, but that's simply not the case. There are areas of significant agreement between the parties here. Both parties are willing to have an independent law enforcement officer obtain the DNA sample. Both parties are willing to have an independent lab develop the DNA profile and conduct the comparative analysis. Both parties will receive the same reports and underlying data. Once an independent lab develops the DNA profiles, Your Honor, there should be no need for anybody to have access to the sample thereafter. And with an independent lab conducting the comparative analysis, there should be no need for anyone to have to conduct further testing. And finally, Your Honor, once the trial is over, there should be no need for those DNA materials to be on file. And as Mr. Lally said, the legislature has provided a mechanism for obtaining third-party DNA post-conviction. So there's certainly a safety net there if the DNA is needed post-trial. Your Honor, protecting the troopers' DNA samples and profiles through these procedures and protocols poses no violations of the Commonwealth's mandatory discovery obligations. The Commonwealth and the defense would be on equal footing with regard to the troopers' DNA evidence. Each party is free to argue the implication of the results at trial as they see fit. As Your Honor can appreciate, my clients are under no obligation whatsoever to provide their DNA in this matter, but they seek to take steps to demonstrate the integrity of their handling of the taillight evidence. In order to provide consent knowingly and voluntarily, they're looking for certainty surrounding who has access to their DNA, how their DNA is handled, and ultimately how their DNA is disposed of. On behalf of my clients, Your Honor, I respectfully request that you issue the protective order proposed by the Commonwealth.
All right. Thank you very much. Mr. Yannetti, it sounds, when I read your opposition, I did not know that there was this much agreement. Did you when you filed it?
I did not, and quite frankly, hearing the argument from both counsel, I think there's even more agreement than I anticipated.
Okay.
Your Honor.
What do you disagree with?
Okay, so our position, Your Honor, is at this point, with regard to the DNA samples versus the DNA profiles.
So where are you in your opposition? What page?
So I'm actually going to the Commonwealth's motion itself with regard to how the DNA samples and profiles will be treated.
Okay.
We did not realize that the Commonwealth was drawing a distinction between the actual samples themselves and the profiles that were generated. It was our understanding that the Commonwealth was seeking to prohibit the defense from having access to either. But I've just
but they're not.
Exactly. I've heard Mr. Lally say today that they will turn over the profile to us. That satisfies us.
Okay, I have a question for you.
Yes.
Since you mentioned Bodie Laboratories, you're the first one that mentions it in the pleadings. How long will it take?
We're not the first ones that mentioned it. The Commonwealth mentioned it in their motion, and we agreed to that.
All right. I don't have that.
Your Honor, it is one of the alternatives that the Commonwealth had. I'm sorry, I can find
Okay,
them.
so we need to find the paper number. All right, but we need to know how quickly that can be done, and we need to see about expediting it.
Typical for Bodie, just because I've recently gone through that with regard to the hair sample.
Right.
It's I think like a 12 to 14 week turnaround without any sort of expedition. So, you know, expediting, I don't know that necessarily that can be cut in half, but it is something that I think can be turned around a little bit quicker than their typical turnaround time.
And Ms. Lundgren, you'll have your clients available, at the drop of a hat to provide this sample? All right, so go ahead, Mr. Yannetti.
Thank you. So, Your Honor, I think the only real conflict at this point, if the Commonwealth is holding to their motion, is their paragraph 7, which states the defendant is not permitted to conduct independent analysis or testing with either Sergeant Buchnick's or Trooper Proctor's DNA samples or profiles. Now, clearly, we won't do that with regard to the samples because we won't have them. We don't need them. But we will have the DNA profiles, Your Honor. And once we do, they, in my view, in my client's view, we should be able to use them for any case-related purpose. We have no interest in, distributing them anywhere or doing anything with them.
Hold on, Ms. Lundgren, I think you should answer this. Why don't you come on up? Is there an opposition to that?
I just need you in front of a microphone. There's one right here. Thank you.
She could take this mic if she likes.
No, because we'll be going back and forth, so you should stay there.
There is an opposition, Your Honor. I mean, I think perhaps the Commonwealth can speak to it. I think there's also a strategic decision, a case-related decision. Certainly, we agree with the privacy interests that the troopers are providing their DNA for a specific reason and with regard to a specific item in this case. And they do want to limit that consent. However, that is more, I believe, a case-related and strategic reason that I would also defer to the Commonwealth to speak to.
All right, I'll hear from Mr. Lally afterwards. Go ahead. Not now. I'll hear from Mr. Yannetti to finish.
Right. So there is other evidence in this case where comparative testing, DNA testing could be done. And in addition, Your Honor, I want to make it clear that our investigation has been ongoing and is ongoing to this day. We may come into possession of evidence related to this case, physical evidence, that we may want to do our own comparative testing on. And once those profiles are released, assuming that there's consent and that the Commonwealth comes into possession of a DNA profile, and the defense does as well by Mr. Lally's admission today, that should be evidence that either side can use for any proper purpose that is case related. So we should not be prohibited from either requesting or doing our own comparative analysis from those DNA profiles if it relates to the case.
What do you want to say, Mr. Lally? We're talking hypotheticals here.
We are.
Right.
So what I would say is the only other identified evidence really, or the bulk of it as far as DNA is concerned, concerns Mr. O'Keefe's clothing, which I don't understand what any relevance that would have pertaining to the troopers' DNA profiles. As it pertains to what ifs, as far as any sort of other physical evidence that counsel would come into possession to, the protective order, while somewhat ironclad, is not necessarily cement. So if there's a request for a modification based on subsequent evidence or something like that, I think that's something that the court can obviously entertain at that point. But really, the purpose of this is with reference to that one specific item.
The taillight.
It does make sense that if there is something later, you come before me on it.
Well,
so that's why I asked you if it's hypothetical. If you have an item that you want to test, I think the Commonwealth has every right to know what that item is.
Okay, our position would be that we should be able to conduct our own investigation in private and reveal the results of those investigations, of that investigation, should we desire to. We have a different ethical duty than the Commonwealth. Clearly, if there's any evidence that the Commonwealth possesses that we'd like to do comparative testing on, we have no choice but to notify the Commonwealth and resolve any disputes before this court. But if we come into possession of anything that we believe is related to this case and should be tested, we don't believe that's any business of the Commonwealth to interject in that. We will have the profile at that point. We can do our own testing and then reveal the results of that testing should we desire to.
All right. Does the Commonwealth want to be heard?
No, Your Honor.
All right.
Maybe we have just a quick second, Your Honor.
Yep.
I've got all of these documents pulled too. We'll go over them in a little bit when this is done and kind of break down some of the
My
work.
co-counsel brings up a good point, which is after months and months and months of requesting access to the physical evidence, we finally appeared at the Norfolk County DA's office on December 1st of 2023 with our forensic DNA collection expert, and he did swabbings of multiple pieces of evidence. So we do have those in our possession.
All right. I had no idea what you were talking about when you were saying hypothetically.
Well, there are two separate issues. There are the items that we've swabbed that we should be able to test, and if we have the DNA profiles of these troopers, there should be nothing prohibiting us from testing them. And by the way, the Commonwealth has the ability to do the exact same testing on their own. And then if there's any other evidence, I still maintain that we should be able to do comparative testing on that as well.
All right. Let's get the samples going. Let's do that, and I'll figure out the rest of this. But let's get who do you have in mind for an independent collector?
Your Honor, I don't have anyone specific in mind, but most local police departments have at least someone who is a detective who is a certified collector. I just
say someone, the defendant, the two of you work out something.
I don't have any issue with working out something with Mr. Lally.
All right, so let's do it today.
That sounds good.
All right, and Ms. Lundgren, you'll make your witnesses available immediately?
Yes, Your Honor, but I just, for sake of clarification, just trying to understand, and as Mr. Lally said, they have not provided their consent yet. They are waiting to hear what the boundaries of the proposed protective order will be in order to provide that, knowing and voluntary consent.
Okay.
So, I mean, we could certainly potentially do the samples and hold them in abeyance and not release them if the court was willing to have them destroyed should the troopers decide not to provide consent based on the bounds of the protective order. But certainly I think they do need to know what those terms are before moving forward.
All right. I need to look at this. I'll do it as quickly as I can. All right. Is that it on this?
Yes, Your Honor. On this motion, yes.
All right. So the third and the fourth motion are sort of in their own category. So the third motion is, it's interesting in that I received the opposition, or the opposition to motion for protective order was filed before the motion for protective order, as I had it in the docket. Who's arguing this for the defendant?
This is the protective order regarding the letters, Your Honor?
Yes.
I will be arguing.
All right, so so what I can say, Mr. Yannetti, is that it appears that you served counsel for the Commonwealth with this motion, but you did not serve the U.S. Attorney's Office. So the U.S. Attorney's Office has a right to be heard on this order, on this proposal that you have. So I need them here. I need them served. So you can serve them and we'll get a date.
I can hear them whispering.
That's fine, Your Honor.
All right, and we'll do it as soon as possible. I do not want to change the trial date in this case. This case will go to trial on March 12th. And the fourth motion, where I said the third and the fourth are sort of in the same category, the Commonwealth's motion for records from Boston Magazine, that needs to be appropriately served and have someone here from Boston Magazine if they oppose it.
Yes.
So I'd like to do this as soon as possible. And given our trial schedule and the fact that I intend that we try this case in March, like everybody served for a hearing here on January 18th at 3 o'clock in the afternoon.
January 18th.
It's a Thursday afternoon. So it's just about 2 weeks. Should give you enough time if you serve these people today to get them here. We can do it via Zoom where it's
Your Honor,
discrete issues. Yes.
we're in trial on January 18th. It's a short trial. Is there any other day that might work for the court?
I don't see any time that we can.
Is the 16th at all possible?
No.
No, no.
Oh, that's back of the holiday, isn't it?
We're both supposed.
I understand that. No, it's not available. We start a trial Monday.
We're both supposed to be in trial that day.
All right, so you can do it via Zoom, or Mr. Yannetti can do it.
I can certainly do it. There's no chance of the 23rd, Your Honor?
No, there's no chance that week.
Okay.
If they had been served, we would have gone forward with that. I'm more concerned about that one, getting that one rolling than the other one. All right. So January 18th at 3 o'clock.
Yeah, the podcast that I did
Right.
is available.
Anything else we need to talk about? Doesn't appear to be.
I think it makes sense to raise this one issue, which is today was the filing deadline for all non-evidentiary motions.
Right, and none have been for evidentiary motions. Today was the filing deadline for evidentiary motions to suppress, things like that.
I understand. So the defense will be filing before the end of business today, not evidentiary motions, but non-evidentiary motions one motion to dismiss and one motion for sanctions and also for disqualification of the Norfolk County DA's office from this case.
All right, so you were not filing motions to suppress.
Correct.
So they're being waived.
Correct.
All evidentiary motions are waived.
Correct. Well, yeah, we'll have pretrial motions in limine. I don't know if they would.
Okay, but everything else, so,
But in terms of constitutional issues.
So file them by the end of today, and if we can hear them on that date, we'll do that on the 18th.
Right, and that would, depend on Mr. Lally ability to respond, et cetera, which, I understand he may need some time, but they will be filed today.
Okay. All right, thank you all.
Your Honor, there's several I apologize. Your Honor, there's several housekeeping matters I wanted to address with the court. In regards to the motions to dismiss that Mr. Yannetti, my brother, just discussed, We do have a motion to dismiss the indictments in this case, and I wanted to lodge the grand jury minutes with the court. They are very voluminous. I wanted to ask for the court's guidance on how you would prefer to receive those.
So when that happens, we typically get them on a flash drive, as well as, Jimmy, how are they filed with you?
Counsel have filed by email and then followed up with the grand jury minutes. So they can do it by a thumb drive.
All right, so a thumb drive, but get a separate one for
We'll
me.
mail that to you so that you'll have a hard copy, the thumb drive. The other housekeeping issue I wanted to address with the court, Your Honor, is, as you know, the court has ordered the Verizon records relating to Jennifer McCabe, as well as the Google Nest records. We were informed by the clerk's office those were supposed to be produced to the court on December 15th. My understanding is you guys have not received anything, and I wanted to follow up on that because that obviously is evidence that we hope to have in advance of trial.
All right, so Mr. Clerk, is your office call or is counsel call?
I've never called.
Yeah. So typically defense counsel calls and says there's a court order, where are these records?
I emailed the clerk's office and they said that they haven't received anything yet. And so that's why I wanted.
Right. So call Verizon and call, who's the other record holder?
Google Nest.
Contact the record holder and say there's a court order, where are these records?
Okay. But
Okay.
you all have not received anything.
I don't know. Jim?
Yes. I'm
Have you received them?
Could counsel come to the sidebar?
Okay.
Absolutely.
Did you see her face? She said, "We have." I've never seen the brother thing either. I've never seen them call like my brother, whatever. I've never seen that before. Or if I have, I've blocked it out. I don't remember having ever seen it before. She wants to get this trial on the road. I think the longer they have to until trial, the more stuff they keep finding. So she wants to get it over with. It's my theory. The whole thing has been a disaster, honestly. Like, no matter what you think happened, this entire process has been, they've made it into a circus, and it's insane. I'll give like a Cliff's Notes version. I think that's their Zoom stuff that's beeping. I'll give like a Cliff's Notes version of everything in just a little bit. And if I know my health has been bad the last few months, and I have not gotten episode 6 finished. I am hoping to finish it soon and kind of get back on track with everything. But the first 5 episodes of the podcast are out about this. And it kind of, the first episode is like a breakdown of everything. And then the next episodes go a little bit more in depth into different parts of it. So different parts of the evidence. So I'm trying to break all that down. So if you want to get some of the information on it, it's on there. And Jennifer Coffindaffer hates my podcast. She said she's never listened to it or heard of me, but she said, I don't know what I'm talking about on my podcast. So I consider that a 5-star review. If Jennifer Coffindaffer hates it, it must be good. Hey, Abe, I think I saw something about this case. Lots of loose ends and unanswered questions. Yeah. And so many problems with the investigation. So many problems with the investigation. So many problems with the people involved. So many problems with the Commonwealth. And Bob, are you still in here? I don't, the video that Lally, put out addressing the public blows my mind still, because I don't understand.
Free can't read, free turtle boy.
Oh, the Zoom people, y'all. Zoom is not going to be allowed in there anymore. The People can't act right on Zoom.
That's it.
Your Honor, if I may, just one last
Yeah, I'll
thing,
play
just
it
with regard to the
after
motion
this.
to dismiss, as far as does the court
Bob, you wanna get on here in a minute?
the exhibits that were presented to the grand jury in addition to the minutes, or just the minutes?
Yes, I assume where you say it's so voluminous, it's the exhibits as well, Ms. Little?
I can produce.
You have to stand in Massachusetts. Thank you.
I can produce the evidence as well.
Okay. All right. So everything.
And I don't have a problem providing that to the court as well. I don't want to duplicate matters, but
Okay.
if it's easier, I can do it. It's fine.
So those would obviously be provided under seal, Your Honor, with.
Of course, they're grand jury minutes.
Correct. That's with regard to the motion to dismiss, the basis of which is the grand jury presentation. The separate
Is it
motion,
McCarthy or Odell?
both.
Okay.
With regard to the second motion for sanctions, Your Honor, the letters that were the issue of the protective order that the Commonwealth moved for, that we've now put off, those will be part of the quote unquote evidence with regard to the motion for sanctions. It's our position, obviously, that those are not exempt from public disclosure. However,
I'm going to keep them exempt until we hear from the U.S. Attorney's Office.
that's why I raised the issue, Your Honor. I just
All right,
wanted
was
to let
that
the
your
court-
suggestion as well, so we could get moving with this motion
Of
to
course.
dismiss?
Of
Okay.
course. Thank
All
you.
right. All right. Thank you.
Thank you, Your Honor.
All right, please.
Thank you.
I'll send you a link, Bob.
So we're going to go to the DA's office now tomorrow?
No, you are muted.
To get your
That's not the point. The point is, I've never seen a circus like this. There have been 110 murders or more.
You can go ahead, yeah.
I've been part of.
He said there's 110.
Grindr sat watching Dr. Grindr kill his wife in 1999. No, had $1 billion defense.
Mike's on. What I was saying, just go there, check in on the front desk, ask for Lieutenant Tully, you know.
Did you hear that? Hold on. I want to rewind that. I love a hot mic moment.
No, you are muted. That's not the point. The point is, I've never seen a circus like this. There have been 110 murders or more.
You can go ahead, yeah.
I've been part of. I've never seen anything that's a quarter of this. It's bananas. Grindr sat watching Dr. Grindr kill his wife in 1999. No, had $1 billion defense.
Mike's on. What I was saying, just go there, check in on the front desk, ask for Lieutenant Tully, you know.
He said, I've never seen a circus like this. Me neither. Me neither. Okay, let me get Bob a link. We'll have Bob from Defense Diaries is going to jump on with us for a bit, and he can answer some of our legal questions too. Let's see. Invite, copy. Bob, I'm sending you a link through Twitter Messenger. It's the quickest thing I could pull up. You gotta go get out of his pajamas. It's early where we are. All right. So here's a little breakdown of this shenanigans. This is kind of like my who's who. All of these are available on the website too. Which website are they on? On brandychurchwell.com. No, they're on 13thjurorpodcast.com. So all of these, all of the stuff that I've done for this case is on 13thjurorpodcast.com. Gypsy Soul, thank you for the super chat. Thank you. Thank you. Thank you. Thank you. I have y'all can tell I am struggling today. My health has not been great. I am struggling today. So I know that I am having trouble getting through as like sharply as I normally do, but health problems suck, right? So bear with me. Will Chloe testify? We must know. I wish. According to Coffin Never, Chloe's living her best life in Vermont or something. But, credibility issues and all. Bite me, Brandi. Your health comes first. February will be 18 years for me, and I and many others know what you're going through and understand. We love you, Brandi. Thank you so much. I appreciate it. We'll get through it. We're getting through it. Just got to trudge through. All right. So I appreciate the super chat too and the support. Thank you so much. All right. So this is kind of like the who's who. So for those of you who are kind of new to this or who aren't familiar with all of the circus as they mentioned it, these are the people involved in the circus. I thank you, Beth Henderson. Thank you for the super sticker. I have this kind of broken down as easy to digest as I could get it, but there are so many people, it makes it hard. There is an updated chart that I'm working on because there are more people that end up coming into the picture after this. So there are more, like there's another sister here and there's more people that come into it later, but this is kind of like the main who's who of everything. And it gets kind of complicated. I know a lot of people have said that like the hardest part they've had about this case is where to start, because this isn't just this person versus this person. This is like a whole big, soup of craziness. So is that even a term? Soup of craziness? It's not. We're going to make it one. All right. So obviously, Karen Reed and John O'Keefe are the two names that you hear the most, that along with Jim McCabe. John O'Keefe is our victim here. He is a Boston police officer, and he was injured and left in the snow to die in January of. And here's the thing too, like there are so many moving parts on this, and I know that on this channel we try to be very victim, oriented, and like we focus on the victims. And I do want to say, like, this case, I saw somebody mention it in chat, which is why I'm saying this. Like, this case is turned into so much, like, as much as you try to go through each trial, like focusing on the victim and justice for the victim, this one has turned into so much of a circus because of all of the extra stuff going on and the issues with, the people involved, and the issues with the court hearings, and the issues with the, all of the side stuff with, like, people involved in it, people following it, and people fighting. And it's gotten so out of hand that it has become such a circus of I mean, he said it right when he was talking about it at the end, like, this has become a circus. So it does get really kind of hard to follow everything. And there's so many motions, y'all. If you saw the folder that I have of, I mean, there's like 180 something, filings, and I have this long sheet, and I have like links to each of them so I can easily access them. And I have like this whole Google sheet that has like all these different tabs, because there's so much to keep up with, and trying to organize it all and put it together and compare stuff and compare who said what and when and all of that to get to organize all the stuff for the podcast. It is so much. Like, I thought that Murdaugh was a lot of work, and it was. I spent hours and hours and hours on that. This one, I did not realize what I was signing up for when I started this podcast. I did not realize how in depth it was. And there are, other, oh, thank you, Dino. I'm sorry, I'm missing these. I know I told y'all I'm struggling today. I'm trying though. Thank you so much for for the super chat. And Debbie's here. Thank you so much for the super chat. I appreciate that. I know that there are a lot of, people who have reported on this. Sleuthy Goosey has, she has a Google sheet that's kind of similar to the one that I made. And she has, a lot of the documents. She has a lot of like the timeline stuff. She's put a lot of work into this. Obviously everybody at this point has heard of Turtle Boy. He's been, I think I called him in the podcast, like the loudest voice in the room. And now there's the, stuff with him being in jail and, like people fighting over that. There's so much has stemmed from this. It has become this crazy, like this case has taken a life of its own. It's been wild. When I was going through everything, there was a lot of reporting on it that I specifically chose not to watch or listen to because I didn't want, y'all know how I am. I wanted to go through everything, read it myself, come to my own conclusions. And I was worried that if I listened to somebody else who had already made up their mind on something, then it would skew what conclusions I came to. So the first thing I always do is pull court documents. Reading through this stuff and charting it all out and looking at it, I was like, wait a minute, like wait, what? How is this happening? How is this happening? Why does that make sense? And when so many things don't seem to make sense, that just intrigues me more and makes me start digging more. And the more I dug, the more I was like, holy crap, this is some wild, wild stuff. There's still a lot of reporting from other people that I haven't heard and haven't listened to for that specific purpose. I don't want my opinions to be skewed by outside influences. I try really hard to focus on, coming to my own conclusions based on all of the facts that I have. And, I'll listen like here and there to, different things or whatever, but I have seen a lot of the fighting on Twitter over it. And that's one of the things that has been so hard because, no matter what you question, there's going to be a whole group of people that are coming like, telling you you're, this or that or the other because you don't agree with them. And the attacks on everybody is crazy. It's been crazy. So I want to make it known that in this chat, I don't care which side you think has good points on what. I mean, I do care which side you think has good points. Let me rephrase. I don't care like if you've chosen a side and you're going to die on that hill. Everybody has their own opinions. That's why we have 12 jurors instead of 1. But I want to make sure that anything that we say in this chat, like I just want it to be known, like I don't tolerate that meanness and that crap. If you agree with somebody, cool. If you don't, cool. But we're not going to do that here. We can focus on facts. We can focus on ideas. We can focus on theories. We can talk it out, discuss it. But if you act like an asshole to somebody else in here, you're going to be gone. It's just, I don't have it in my mental capacity to deal with meanness in here. So just so you know, we can talk about it all day long. I have a lot of unanswered questions, but I also have a lot of things that I have made my mind up on, and my decisions don't have to necessarily, y'all don't have to agree with them. Again, that's why we have 12 jurors instead of 1. But anything that we do discuss in here, because we're about to have Bob come on too and answer some of our questions about like the legal stuff. I'm going to give you like a Cliff Notes version of this, but anything that we do discuss in here, I just want to make it clear. Like, I know that there's a lot of passion around this case, but we're all going to be respectful of each other while we're talking about it. All right. So I have the podcast playlist on YouTube that you can listen to, the first 5 episodes that are done. I also have it on, it's like on Apple and Spotify and all that good stuff too, if you want to listen to it. And it kind of goes down into like more of a deep dive on it. First episode is kind of like a general overview and all of the questions that arose and why this has become such a big deal. And then the rest of them are like kind of slowly walking through the course of the investigation and all of that. But a lot of freaking time goes into it. So there is a lot of stuff covered in that if you want to do more of a deep dive on it and hear stuff. The who's who gets pretty messy. But these are the main ones. So like I said, John O'Keefe is, of course, our victim. Karen Reed is the one on trial. What is Coffin Daffer's issue with me anyway? She was going around Twitter saying that Karen Reed is guilty and whatever. And I told her, I think that, and she also got a lot of information wrong. Fact checking isn't one of her things. So, which, whatever, but she got some information wrong. I corrected her, and she was going around saying that Karen Reed is guilty. And I told her that that's really irresponsible to use such a big platform to, try to convict somebody in the court of public opinion before they even go to trial when there's obvious reasonable doubt. If nothing else, I'm not even going around, because I don't want to be, I want to be very careful with my platform. And I'm not going around saying like, this person did this and that person did that. I'm saying there are questions, and we need to look at this critically, because there are issues with the prosecution. There are issues with the investigation. There are issues with the people involved. There is, if nothing else, at the bare minimum, there is reasonable doubt. At the very bare minimum, there is reasonable doubt. And that in and of itself requires an acquittal. And let me say that we haven't gone to trial yet. So based on everything that is available to us to look at this point, at the very bare minimum, there is reasonable doubt. So it is incredibly irresponsible of her to use such a large platform to go around telling everybody she's guilty, she's a horrible person, she's this. And I told her that, and then all of a sudden she said that she doesn't like my podcast, but she also said she's never heard of me. And then she blocked me and continues to talk shit about me. So, whatever. Former FBI. Bless her little heart. All right. And I think like 74% of us or more in here are blocked from her shit anyway. Does she come into our chat? No, because she's never heard of me. She just doesn't like me, is what she said. Or she didn't say she doesn't like me. She doesn't like my reporting, but she's never heard of me. Depends on which day you catch her on. All right. I just, you know what? Let's just be petty for a minute, because I don't feel good. And you know what? We'll just be petty. We're going to do a poll. Are you blocked by Jennifer Coffin Daffer? Just curious. Heart poll. Just curious. All right. So this whole thing happened. Here's your little Cliff's Notes version. This whole thing happened. They had gone out for, John O'Keefe was out with a friend, having drinks. Karen Reed came and met him. The Alberts and McCabe's all have their connection because of Brian Albert. He is Boston police officer. He's married to his wife, Nicole Albert. Nicole Albert's sister is Jen McCabe. And Brian Albert's brothers are listed here with their wives. These are kids. This is the dog, Chloe, long live Chloe. God bless her heart. We hope she's okay. Whole nother story. But these are kind of all of the people involved, but this is all like one big family, right? You can see behind them, this is the house where it all happened. These are the ones that live in that house. So these are kind of the people that are initially involved in that night. 84% of you have not been blocked by her yet. 83%. That's incredible. That's awesome. Tell her we said hi. So the night in question, they had been out drinking. John and Karen were at one bar. They ended up going across the street to the other bar to meet up with the Alberts and McCabe's that were there. They ended up going to that house, this house right here that Brian and Nicole live in. And at some point, there was a snowstorm coming in. It was going to be like one of the biggest blizzards in recent Boston history. It was supposed to be coming in that night, but yet somehow they still all decided, hey, there's a blizzard coming in, in a few hours, but let's keep this party going. Lauren, thank you for the super chat. I'm friends with TB and followed from day one. So much unconstitutional suppression of evidence and free speech, free Karen and TB, FBI coming down. Yeah, she's not my favorite. Thank you for the super chat, Lauren. And yeah, that's one of my biggest issues with this has been like unconstitutional suppression of evidence and just some of the hearings that have happened. Watching them, I have not been a fan of this judge at all. I don't think that she's been impartial. I don't think that a lot of her stuff has been fair. That's my personal opinion. I don't think that she has done a good job with this, and I don't like a lot of the rulings that she's made. I don't like the attitude that she's had toward this. I don't like how they're so flippant about, this being like about this trial. I just like, oh no, I'm not going to recuse myself. Oh yeah, I have ties to them, but whatever. It's not important. It's whatever. I don't like it. I'm not a fan. I think that this whole thing has been unconstitutional. And that video, we're going to talk to Bob about that in a minute too. The video that Lally put out, addressing the people. Now, keep in mind, he's putting out a video talking about this case, and we're going to watch it. He's addressing his own jury, like he's addressing the jury pool, saying, we'll watch it. It's never in my life have I don't even understand it, but what do I know? Real Boring Housewife. Hi, I haven't seen you in a while. Welcome back. It is good to see you. Hi. All right, let me. Oh, Bob had to get out of his pajamas. So he'll be here in a minute. All right. So, anywho, they go to this house. They're going to continue this party. Karen and John leave together. They end up going to, let me pull up my Google thing, my Google Sheets. They end up going to the house. Where is it? Here it is. Oh, I still got that open too. All right, pull it up. There's questions about what happened on the way there, when they got there, and afterwards. Like everything after they leave those bars is what has been the biggest arguments with everything. All right, bookmarks. My drive. Oh, I need a nap. It's only 9:40 and I need a nap. All right, let's see. It's a Karen Reed file. All right. All right, I'm going to pull up. This is statement timeline. Okay, I want to show y'all something too. So these are kind of like the who's who. I want to pull over this. Okay, I have everything you can see on here. I have everything kind of color coordinated to show. I'm going to end our poll. That was a petty poll, but I don't feel well. I can do petty polls when I want to. I have everything color coordinated. So here's one of the things that when I started going through this is one of my first big red flags. Okay. The colors over here are, I did everything color coordinated. Number one, because I'm kind of psychotic, but also number two, oh, I didn't think about the press conference. Hold on. Let me look. They might've done a press conference. If not, we'll rewind it. I wanted to put every statement that was made in time order and compare it. So compared to like I wanted to compare the, that feed ended. Let me see if I can find Boston. They ended the feed, and normally they'll have one if they're doing the press conference, but I didn't see. I don't see one. I might have to start streaming from my bed. I don't see one. So if y'all see one that I'm missing, send it to me and we can show it. All right. So the first thing that I did, I put all of this stuff together. To compare the notes. And one of the first things that popped out to me was how many times the story changed and how many times there were different versions of what happened. Oh, look who's here. How many times? Hi.
Buenos dias.
And how many times?
Hi. Sorry, I was I was still in bed. You know, it's early here. I was watching you, you know, in my pajamas in bed. Then I had to make my coffee, let my dog out, clean his paws. So all that good stuff. Well, hi. It's been a
Hi.
minute. How are you?
It has been a minute. I'm good. I was just telling him, I was like, you're gonna have to forgive. I'm glad you're here because you can answer questions. I was telling them, I was like, I'm about to start streaming from my bed. And, you know, because you and I are on the same time zone. We're both central.
Yeah.
So, you know, I woke up.
feel
I was
your
like,
pain.
I'm still not awake all the way.
Yeah. I forgot that hearing was coming up today, and I was on YouTube and I was looking through my subscriptions and I saw that you were streaming. I was like, oh, cool. So I set my alarm to get up. I still overslept a little, but you had to get up early for that East Coast stuff, you know?
Yeah, I know. And most of the trials that I end up doing are on East Coast because most of them are on the main part of Florida. I'm in Florida, but I'm the Panhandle, so I'm still central. I'm basically like just Southern Alabama, y'all. I'm not even like Florida doesn't even allow us to, you know, claim it half the time. But most of Florida's on the East Coast, and there's so many Florida trials. So, you know, a lot of the stuff that I end up doing is East Coast. So I'm always up early anyway, I guess. But
yeah, I think it's like, it seems like almost a majority of trials that we're seeing are East Coast. You know, we got the Carolina stuff. You know, we've got obviously this one. I mean, everything like, and it's weird because a lot of courtrooms, aside from Wisconsin, which seems to really allow cameras in, like our laws here allow for it to have cameras in the courtroom. The judges at their own discretion just never allow it. You know, it's weird. It's annoying in Illinois. Like you're like, I don't know that I've ever seen any Illinois trial streamed ever. You know,
I'm trying to think. I can't think of one off the top of my head.
I can't think of any either. And like when I tried the Garcia case in Omaha, like a week after that trial ended, they approved cameras in the courtroom, which that trial would have been insane. Like everyone would have hated me.
Yeah.
Because I tried the hell out of that case and I was like bullying the exotic dancer on the stand, you know, because she was like their star witness. Everybody like, what the fuck is wrong with this guy? He's such a dick. You know, but like she had like really powerful testimony, you know, that we spent like, I don't know, 100 hours discussing like how we handle her. Do we go at her aggressively? Do we handle her with kick gloves? Because, you know, we were trying to really show that she wasn't credible, you know, and it's like, people don't understand that, like, typically, Jenny, I know all about that hot mic, girl. You know that.
Oh yeah.
Yeah, I've got that. Like I've you know, it's all my hiccups in my YouTubing. I have a lot of them. So it's great to see all y'all. I love you, all the 13th jurors. You guys are amazing. Are you hanging in there, girl? Like with the health stuff? I'm sorry you're going through that.
I'm trying. I know I'm it, you know, I think the hardest part for me is like just the exhaustion that comes along with, you know, having to go through stuff. So so I'm not on my game like I'm used to being. So it makes it a little bit harder to get through it, but we're getting through it. I've got
I have no doubt. Doubt you'll play through, girl. You know, it's like it'll get better. You know what I mean? Just as long as you know that. And we all love you. So you got that going for you too. And we, we both hate Coffindaffer. So I think I was like one of the first ones to get blocked. Like, cause I was doing that before she was even on Karen Reed, when I was doing it when she was convicting Koberger, which, look, like, at least that guy, and I don't know where people fall on that, but like, at least in terms of what we know evidentiary wise, that guy, at least they have a case. You know what I'm saying? It's like, but she was still doing the same thing. And, I was doing the exact same thing. I'm like, factually, you're incorrect. Like, on the law, you're incorrect, and I wasn't coming at her like a jerk. I was just like, oh, well, Jennifer, I want to let you know that you're misstating the law. Okay. And you weren't a lawyer, you were a fed, and like, cops and lawyers do not have the same education. Believe me, cops do not understand the legal process. I know that sounds weird. People are like, well, they arrest people. Well, yeah, that doesn't mean anything. Like, when a cop arrests somebody, like when they arrested Karen Reed, it wasn't Proctor's call. It's whoever it was Lally's call. Like, there's always depending on how nefarious this was. You know what I mean? Like, Karen Reed's a bad example. Just say in a normal case, if they make an arrest, say it's 2 a.m, it's not like a completely obvious case. Like, it was like, they're going in and arresting on a domestic, where clearly they've got a battered woman. They're taking the guy in. They know what to charge him with. If you've got a case that's got a fact pattern that could go a bunch of different ways and fit in a bunch of different statutes, they're always getting the authorization to charge that person from a state's attorney. There's always a state's attorney or a district attorney or a county attorney, depending on where you're at, that is on call. So the cops are calling them no matter what the hour. That guy's got or gal's got the 24-hour hotline, bat phone. Yeah, this is what we got. And then the state's attorney will say, okay, this is what you charge them with. Because the state's attorney is the one who has to try the case. They're the one who understands the statute. They're the ones that understand what the burden of proof is. Cops don't understand any of that. So just as long as people understand the difference between what lawyers know and what cops know, starting as a baseline, will be good. Because a lot of people just don't know. People just think that cops know all the law. They don't. Like, it's just, it's facts. Like, trust me. I've been doing this for 20 plus years. I've been cross-examining police for 20 plus years. They don't know shit.
Yeah.
But like, and that's not to say that there's not great cops out there, because there are. But there's also awful ones. And their legal education just is, they go to the police academy. They learn how to, arrest people. They learn how to handle, situations where they're clearing a house. They're really learning how to protect themselves, because they do have a very a dangerous job, man. So, but whatever. I digress. I'm going to step off my soapbox now.
I think that a lot of the times too, like, one of the reasons that I called this like 13th jurors, because like, I'm not an attorney. I'm not, an officer. I'm not. And Coffindaffer said, like, she even has posted, like, Brandi Churchill has no credentials. Okay. But I have eyeballs, and you know what, like, my thing is I have a logical working brain, and it's jurors who decide the outcome of a case. It's not, like, the attorneys decide how things are being presented. The judge decides, what's going to be shown, like, or the
100%.
law is supposed,
100%.
but it is jurors who look at the evidence that's presented, and they are the ones who determine it. And so that's why I wanted to call this 13th juror, because I noticed in the law 2 world, there were so many people who were like, you're not an attorney, you don't know what you're talking about. Okay, but attorneys aren't the ones who are making the decision on the outcome. So I wanted this to, kind of be a place where everybody, no matter what your background is, anybody who could possibly ever be in the jury pool, or anybody who couldn't and just wants to watch, could, look at this and talk about it and theorize and have opinions. And that's what I love about this. And I love having, people on like you, who is, a defense attorney. And then we have Detective Dean O'Kelly from the Thomas Randolph trial. He's one of our members. He's in here, like, so we get his perspective on, like, he's a homicide detective. So like investigation, stuff. And like, he'll give us insight on interrogations that we're watching and stuff like that. I love hearing all of the different viewpoints.
Totally.
And
I love your concept, and frankly, you are the true crime community. And like, if I'm going to compare somebody who comes with receipts, I don't give a shit what your background is. If I'm to compare you to Jennifer Coffindaffer, there's no comparison. I'm going with you all day because I know you do your shit. I know you dig in. I know you research. I don't care if you're a lawyer or not, or a cop. It makes no difference. Receipts are receipts are receipts. You do the work, you dig in, you figure out what the facts are, and you don't come with bullshit. That's what matters to me. So it's that simple. And you don't need to be a lawyer to watch. Like, if you all knew everything about the law, there wouldn't be any room for me. Like, what would be the purpose of Bob Mata? I couldn't come on. If you all knew what I knew, then I'd just be a dude. So I love your concept. I think you're awesome. And like I said, you are the true crime community. I think the value that I'm able to bring is that I've been in the system for 20 years. I kind of know my shit, and like, I like being able to educate people if they have questions. I fill in the gaps. Y'all talk about the stuff that really makes it fascinating, and then I try to help give it context by explaining kind of what the rules are. You know what I'm saying? So I love the way it works, and I think it's great.
So I want to ask you from a defense attorney's perspective too, that because we mentioned it before you went to go get out of your pajamas and all that. The video that Lally put out.
Yeah, I didn't see that.
Oh, you haven't seen it?
No, I messaged you. I'm like, could you throw it up? Because I haven't seen it.
Yes.
Like, I'm up on this case, but I'm not up like you're up on this case. Like when the whole Turtle Boy thing kind of like exploded, I was like, you know what? I'm just gonna like, as much as I love the fact that he's out there advocating, he's just so aggressive with it that it is like a content creator. It's scary to like. And Coffin Daffner was talking the same shit. Like, as soon as he got arrested the second time, she's like, "Oh, but like Bob Ma defense diaries, better watch who you hitch your wagon to." And I'm like, I didn't hitch my wagon to shit, lady.
Yeah.
Just because I happen to agree that I think that there's reasonable doubt in this case, like by a mile, does not mean that I hitch my wagon to anybody. So, whatever.
That's my thing too. Why can't I find the video? Hold on. I'm going to pull it up while we're talking. But that's one of my things too. I keep saying I'm not being, we haven't seen all the evidence. We've only seen what they've shown us so far, what's been in court documents and what's, whatever. So I'm not going to pretend like I know exactly what happened that night from minute to minute. But my thing is, there's so many issues that have come up, and of course I'm going to have questions. And there are some things that are factual that we can see that are issues. And
I agree. And look, like, we always need to wait for trial. Always. Like, we like that. Like, you and I are both, like, anybody who watches trials and we give analysis and we give our thoughts on it. We all know that you have to wait to trial. But this case, more than most, we have had a lot of the evidence and the defense's theory of the case, much like what's happening in Delphi, where the defense threw their theory out, the Odin thing, where everybody's like, that's crazy. But like typically we don't get that much of the defense's theory. Now, here in Karen Reed's case, when they filed their long motion, basically calling bullshit, calling corruption, all the things that they brought up. But then they came with receipts, like about how the wounds on the arm look like a dog did it and how the tail light was intact. So we have more facts than we typically do prior to trial from the defense side of it. And we know what the state's theory of the case is. We typically always do because of the probable cause affidavit. That's never a mystery to us. Does all this evidence have to be tested at trial? Yes, of course. But based just on the two theories alone, there's reasonable doubt. I don't get like Coffin Dapper's whole thing with this being like some massive conspiracy. Like, I was almost going to message you when I saw your pod was coming out, which is great, by the way. Like, it's typical Brandi, just digging in facts, receipts, all that shit. Just it's great work. But I was going to be like, dude, don't name it conspiracy because it gives credence to the people that are poo-pooing it. Because when people think of conspiracy, they give it a negative connotation. You know what I'm saying? Like, to me, it's more of a cover-up. I don't think that anybody conspired to kill John O'Keefe, but I think that once he got his butt beat in that house, and they ended up, they're like, just put them out in the light. What my theory of the case is that something went down in that house. Like these were not these guys were not thick as thieves. Yes, they were all cops, but like John O'Keefe was not super tight with the Alberts, right? Like, I mean, he went there. I think that there was some kind of, beef between his kid and, O'Keefe, because they were neighbors, right? I think the kid showed up. I think everybody's drunk. Like, and if you drink and you're a guy and you're in Massachusetts and you're a cop, I imagine hammers may have gotten thrown, and I think shit got out of hand like really quick. I think that they just thought that he took a beating, and they're like, yeah, toss it, and they're thinking that they'd put him out there, just kick him out of the house. They probably drag him out, thinking he'll wake up and stagger off.
Yeah.
And when that doesn't, like when he's still out there, like an hour and a half later, that's when panic starts to set in, right? And they're like, that's when you get your 2:29 a.m. Like somebody probably called and said, like, the dude's still out there. And like John McCabe's like, oh my God, what? Like, how long does it take for somebody to die in the cold? Like, how long has he been out there? Like, you can just envision, like, it's just so much more plausible than him being, hit at whatever speed. He's not flying, even if it's 20 miles an hour, he's not flying 20 feet through the air into the middle of his lawn, or, a good distance, whatever it is, 15 feet. And like the wounds are just inconsistent. Like there's no bruising on his body anywhere. Like forget about the fact that the injuries on his arms are completely like there's no explanation other than that looks exactly like what a German Shepherd would do. Like if you've ever watched a German Shepherd training video, like just Google it, like throw one up. Like it's always, they have the big pad on their arm and the shepherd's attacking the arm. It's exactly what his injuries look like. You got the claw marks on either side of the elbow, and then it looks like his teeth were on the elbow. So I don't know. Whatever the case, it's all going to get tested. But where we stand right now, it sure the hell looks like reasonable doubt. But I'm biased. I'm a criminal defense attorney. I always think that not people are innocent, but that the state didn't meet their burden, which is two very different things.
Two very different things. Yeah.
Yep.
But there's that quote. And like I said, like with all the stuff I'm going through, like my brain is not as sharp as it normally is. So I can't remember what the quote exactly is, but it's something about like that. It is better to have,
Yes. Right. You're talking about having, like it's better to have 10 guilty people, or whatever the thing is, it's better than have like 100 guilty people than one innocent person go
than one innocent person.
10 guilty people walk than to have one innocent person go to jail. Which I of course agree with.
And also, speaking of my brain not being as sharp, somebody pointed out that I said this is Lally. It's not Lally, it's Morrissey.
Okay. I wouldn't have known the difference. They look like the same dude. Oh, and Jedi, it is the verdict. Okay.
All right. So this is the video. Now, this is the DA, and I get that like I've never seen a DA release like a video to the public, before like this. And I'm sure it may have happened somewhere. I just haven't seen it, but listen to what he says. Have you seen this? You haven't seen this, Bob?
I have not.
Okay.
So what was it? When was this done? Early? More recently?
It was
within a few months.
Yeah. It's like 4 months ago.
Okay.
So this is him addressing people about the case.
This will be the first statement of its kind in my dozen years as Norfolk District Attorney. The harassment of witnesses in the murder prosecution of Karen Reed is absolutely baseless. It should be an outrage to any decent person, and it needs to stop. Innuendo is not evidence. False narratives are not evidence.
Okay, I just want to say false narratives. Right there, he is 26 seconds into a video, and he's saying to his own jury pool that the defense's narrative is false.
Yep.
Do you not think that is just
Yes.
And again, I'm not an attorney, but to
Yes,
me,
I think it's repugnant. And like to me, it's sanctionable, because like as the defense, you'll never see us, and if we do, we get hammered in the
yeah,
media, we get hammered by the judge. If we were to come out as defense attorneys and make a statement like this, talking about how because the one thing that I'm always trying to teach people in my podcast and on my YouTube channel is that these are both theories. These cops weren't there. This
right.
guy wasn't there. The defense attorneys weren't there. We were not there. No one that is involved in prosecuting the case was present at the time that the crime committed. Everybody's cases are theories, and that's all it can be because we don't know. We weren't there. They developed a theory based on the evidence and based on what they think happened, based on who knows? In this case, like that's where it gets murky, right? Like, I
Yeah.
mean, you've got the whole Proctor thing. I mean, where there's smoke, a lot of time there's fire. It seems very incestuous, this case, in terms of the way that it went down. You got police involved, and anybody who's like of the mindset that there's no corruption in law enforcement is like, if you're still thinking that at this point, like in the 1950s, 60s, 70s, fine, officer friendly. They never do any wrong. Okay, well, if you still think that, knowing that everything that we've seen in like in this country for the past 20 plus years, and it all changed with cell phones. Like when people started being able to take video, that's what put cops on blast. Like that changed the game. And it started with the Rodney King thing. Like black folks forever were saying, oh my God, like the cops are beating the shit out of us. They are treating us like animals. And like everybody's like, oh, you're probably exaggerating, until they saw it happening with their own eyes. It was kind of like the concept of what Martin Luther King was saying, we're not going to fight back. We're just going to let America see how they treat us. And which was effective. Like Malcolm X is like, oh, no, hell no. I'm not going to stand here and take it. And Martin Luther King thought it was more effective to let the people see what was happening. So it's like, whatever, dude, like I'll get in some weird rabbit hole, but do you understand what I'm saying? Like all we're talking about is two theories here. So yes, I think when this guy comes out that it's sanctionable because he's shitting all over the defense's theory when all that they have is a theory themselves.
Yeah. And I think that's my biggest part, because it's like, this is one of those things that is going to go to a jury to decide, and to come out as the district attorney and say, because okay, you're a friend and you're a defense attorney, and you know what I mean by this. But when people hear things from a district attorney as opposed to a defense attorney, they will automatically, like most people, like just the general public, will automatically give more credence to what
100%.
a defense attorney says or to a DA says than a
100%.
defense attorney, because a lot of like that systemic, it's
built in. It's
built into us.
It is. And look, like our true crime consumption for the better part of the last 40 years, since they started making documentaries and, CSI and all the crime shows that we love, all making the cops out to be heroes and the prosecutors to be the heroes. And even when you get into reality TV, if you want to call it that, with documentaries, who do you see on there? You see the prosecutors and the cops are always the main focus of everything that you see on Discovery ID, on Oxygen, on all the things that we love to watch. And then they'll put the defense attorney as the scumbag at the end of it, like the guy trying to get people off. I've spent so much time trying to explain to people what defense attorneys really do. And I've made a huge headways. Like one of the reasons that I've gotten a following is because I like, it's the thing that gives me the most joy out of what I've done. When I decided to leave practicing and do this, and I wasn't going to lean into the defense lawyer thing. I'm like, man, I'm trying to get away from doing that. But I realized immediately what you're talking about, that everybody's preconceived notion is, if the guy has a badge on the stand and he gets on the stand, they are more apt to believe him than a normal citizen. And to your point, our first questions when we are voir diring jurors, potential jurors, is do you think because an officer has a badge and he's sitting on the bench that he is more truthful than your average juror? And if the jurors are being honest, which most of the time they are, they'll always say, yeah, I do. I think, because like you said, that we have been trained to think that. Like,
Yeah.
you know what I mean? So
Yeah.
it's swinging the other way now, but it's still, we've got, you're still going to have people, and this is not an indictment of all cops. Like, I always make that distinction. Are there dirty cops? Of course. Are there bad cops? Yes. Are there bad lawyers? Yes. Are there bad judges? Yes. Are there bad doctors? Yes. Are there bad teachers? Yeah. There's bad everything.
Right. Which is why I think it's so important to not have comments like this, to where because there's going to be bad everything. And I think that going into this, it should be the information that's being provided. I've seen some terrible defense attorneys say some terrible things, and I've been pissed off. Like, I have had to mute my mic on here before because I get so outraged that this defense attorney could try to, twist something when we've seen evidence to the contrary. Like, but I've also seen, like, I think about like the Travis Rudolph case where, we're sitting here watching and I had to mute my microphone because the prosecutor was doing the same thing. So but that's why I think like it is a lot of times like systemically inside of us to automatically, like, because and like you said, like the shows and the movies that we watch and everything, it's like you see, these people that are like heroes providing justice and putting the bad guy in jail. So that's the way that a lot of times like we go into things seeing them, and sometimes it takes a minute for us to realize, oh wait, that's not what's going on here.
Right.
So I think that having the first 26 seconds of this, the DA saying the defense is presenting a false narrative, and this is the DA saying this to potential jurors.
Flame throwing the potential jury pool by poo-pooing the defense's theory where he's got the platform to go out and do it. He just calls up whatever press he wants. He says, I'm having a press conference and I'm going to go just flame throw the defense's theory. Right. And, because he's the state. And the other distinction that I need people to understand, if they follow me at all, they know that I'm huge on this. What we do as defense attorneys, y'all, is that we are the ones who protect the Constitution. We are the ones who protect all of our rights, not these guys. They are the state. They are the government. The Constitution was written. If you understand anything about the Constitution, that is a bunch of rules about what the government cannot do to us as citizens. They cannot make laws that will abridge our free speech, our freedom of religion. They're like the Constitution. Like, people don't understand the Constitution. When defense attorneys are filing motions to suppress, which we heard this morning, that this was the filing deadline for motions to suppress, which Yannetti said they weren't going to be filing any because, and you heard him say it. We aren't aware of any constitutional issues. So that's what he's talking about. We file those because if we think the cops did dirty on a case, if it was a unreasonable search or seizure, which is exactly what the Fourth Amendment says, we have a duty as lawyers, as defense attorneys, to protect the principles of the Constitution and file those motions. If something gets suppressed, don't blame the defense attorney, blame the cop for breaking the law, for violating that person. Because if we let them do that, if we see a case, say it's a horrible, horrible case where somebody's done something horrible, but the cops cheated to get there. If we don't file that motion, we let them get away with it. That creates the slipperiest slope, because if we're not filing those motions to suppress, and the teeth that it has is when we win a motion to suppress, the judge has, unless there's an exception it'll fit to, like good faith or, inevitable discovery, which a lot of times judges will hang their hat on. But if they suppress that piece of evidence, which is the key piece of evidence, which means the state's case evaporates and the guy walks, people want to blame the defense attorneys, blame the cops for not doing the job right on the front end, because that's who's to blame. And the hope is that when the judge suppresses that cop on their next case is going to follow the law. Because if we start living in a country where the cops can do whatever the hell they want, they can break into our houses without warrants, they can search our vehicles without our consent, they can stop us and search our person without consent. Trust me, we don't want to live in that country ever. So that's what we do. That's what defense attorneys do. We defend the principles of the Constitution, not the state. The state and the cops are the government, people. Just understand that. like as a baseline, just know that. So yeah, when I see stuff like this, and again, and it's all through the lens of exactly what you're talking about, is that people just have a tendency to think that they are the good guys always.
Yeah.
And are they? Of course, when monsters are put away, we're all thrilled.
Yeah.
Like when Murdoch is convicted, we're all championing Creighton Waters because, like Murdoch is a piece of shit, so we were all through. So we, like, in cases like that where it's obvious that this guy needs to go away, you're thankful for the prosecutors doing a good job and what they have to do. But, for every Murdoch case, there's a case that isn't that, and there's cases. So we just need to make sure that everybody's doing their job properly, which is the point of trials and the point of pretrial motions. And like, I love the fact that they're starting to have these types of motion days. Like, these were never streamed back in the day.
Yeah.
Like, never. Like, if you think about it, now I've been doing this forever. I always tell people the real war in any case, in any trial, is the pretrial motion phase, because as you aptly noted, that's when we figure out what evidence is going to be admissible and what's going to be inadmissible when we get to trial. When you're watching a trial, you're seeing the end fight. You've missed the entire battle because, like you were saying, in this case, there's been 100+ motions filed. These guys are fighting. Every motion is fighting about, we want to be able to test evidence. We want to keep this out. We want to be able to get this evidence to test it. You know what I mean? They're fighting about what evidence they can get in order to test, which ultimately they're going to have motions in limine right before trial about what's going to be admissible, which can be.
Can you explain what a motion in limine is? Because there was a couple people that were asking what that meant when chat went through a minute ago. Can you explain what that means?
Yeah, a motion in limine is basically, it could be anything that is at issue prior to going to trial. So say, for instance, you've got a case like in the Natalia, like, I don't know if you guys have been watching anything with the Natalia Grace thing. Okay. So when they, like, that's the orphan that came from the Ukraine, and she was a little person and they didn't know if she was 9 or 22. And they went into a court and had her adjudicated as an adult, but it seems like she was really a 9-year-old, and they left her in an apartment on her own at 9 years old as a little person. So they ended up charging, the adopted father and the adopted mother with neglect of both a child and a dependent. There were 4 counts. So in that case, there was a motion in limine, which happens right before trial. Like, so you have your motion to suppress, which happened now, and there's filing deadlines. But like in that case, they didn't want the use of the word child to be used by either side because she had been adjudicated as an adult. So like anything that we want to have kept out at trial, or the state wants to have kept out at trial or admissible at trial, those motions in limine happen right before trial in order to clear up whatever remaining issues there might be just before trial. So they're just like motions, but they're typically about admissibility of evidence. Okay. And they happen right before trial. It's just a timing thing in terms of motions in limine. They're not that much different than like a motion to suppress. They just happen to happen right before trial typically. Yeah. And it could be all kinds of stuff, like any kind of housekeeping issues, you file motions in limine.
Yeah. And we had talked about the stuff getting, and we'll watch the rest of this. It's only a 5-minute.
Yeah, video. I want to hear it. I'm sure it's tasty. I'm sure he starts attacking. Does he go after Turtle Boy? This is an attack on Turtle Boy because it's basically the defense put out their theory, and then that's when he became aware of it, and he started he just had a really loud voice about it. He, for whatever you think about the guy, and he's definitely aggressive in terms of getting information out there and getting like his narrative out there and the defense's narrative out there. I mean, he did really put this case like kind of all in our public consciousness. I had never heard of the case until I heard about what was going on with Turtle Boy, so it's like, but it's like some of the stuff that comes out is like, oh my God, it's a lot. But he was the guy is like, he says stuff that I'd like to say sometimes, like, like in terms of just being like, oh man, like calling bullshit on things, where I try to stay a little more objective, just because I'm trying to build a platform, be a creator. Like, he doesn't care about burning bridges. I do, that's like one of my things.
You definitely always know what he's thinking.
Yes, you do.
However, what evidence does show is that John O'Keefe never entered the home at 34 Fairview Road in Canton the night he died. Location data from his phone, recovered from the lawn beneath his body when he was transported to the hospital, shows that this phone did not enter that home.
Does it?
Okay, that's what I was gonna say. I stopped this. This is one of the things that I went over in one of the podcast episodes, because he's saying that the phone doesn't show that it entered the home. But it depends on which part of the phone evidence you're looking at. Because one of them, like the Apple health data, is different than the like location data. And in one of the episodes I did, I was like, okay, well, so which one of these are we to believe? So I pulled like previous trials, like I think one of them was for the Murdoch trial, and then I pulled like all these studies and stuff to see which one of these would we rely on more heavily. This is one of those things, and I call it like like because I always say data doesn't lie, and I always say, like, there's anchor data, like the things that are like just there, they're not moving, you can't argue with them.
Right.
This is one of those things that, there's two different parts of the data that give conflicting parts. And it's like if this is exactly what happened, some of the data's right here, and some of it's over here, and so it's a little bit harder. And
there's wiggle room, right?
Yeah.
And and the state really likes to hang their hat on the Waze data, like the Waze data, in terms of, where he was located at what time, is what they're using to say that it's conflicting with the phone's data in terms of his health data and his steps and things like that. So they're using other applications on the phone in order to try to reconcile what seems to be the case as far as like the health data on the phone, so that kind of wiggle room is, and that's where the law is. That's where every trial is. Like, everything's about interpretation in any case. It's like the theory of any case, again, is the interpretation of the state, and then the interpretation of the defense attorneys could be looking at the exact same evidence. And like, just look at, and you did an amazing job breaking down like the search, the how cold or how long to die in the cold, that search, in terms of the Cellubrite grab when they extracted all that information, because the state's claiming, oh, that happened at 6:27, and it was some kind of like, like your explanation was frankly the most helpful to me. And I've been in court fighting Cellubrite. Like, those extractions are like those reports are very simple to read, and they're super accurate, so it's like, They were coming up with like some state trooper is their expert, coming up with some BS excuse as to why that search didn't happen. I thought your episode on that was great, by the way.
Thank you. Yeah. Thank you. And I think that when you have different interpretations of data, I think it's important to, again, let that get to the jury. But here he is saying, this is the one that's right, and he never entered the home, and that's not for him to say to the public.
Right,
that's for the jury to decide. And I think that, so here we are again at 26 seconds the first time he made, in my opinion, a huge mistake. 44 seconds into the video is the second one. I think again, to me, that's
he's giving his closing argument right now.
Yeah.
Like, that's what he's doing. He's literally giving his closing right now to like all the potential jurors that are out there in Massachusetts and Canada.
Yeah. All right, let's see what else.
11 people have given statements that they did not see John O'Keefe enter the home at 34 Fairview that night.
Okay, so again, and you actually nailed it right there when you said, like, it seems like he's giving his closing statements, because again, he's giving weight to the credibility of one side of this case versus the other, and that's super inappropriate to me
100%.
to put out to the public.
100%. Could not agree more.
0 people have said that they saw him enter the home. 0. No one. Some have, without any evidence, pointed to 18-year-old Colin Albert.
Okay. again, without any evidence is, and look, I'm not one of those that's saying like, oh, Colin did this, whatever. I have been very clear about, I don't know what happened. I can understand where the theories are coming from with the Colin thing. I understand the stuff that's coming, like where it's coming from. But the reason that they didn't just pick somebody like, oh, he seems like a bad dude, let's pick him. There are things that led them to that theory. And I don't think it's up to him to say whether or not that's evidence, because it would be just as easy on the other side to say, like, there's no evidence against, Karen Reed. I think it's the same thing. Do you agree? Like
100%. I mean, and that's like, he is dismissing the entire defense's theory by saying that we had 11 people in that house, or 11 witnesses that all testified that John O'Keefe never came into the house. Well, that's where the reasonable doubt is. Like him coming on here without the benefit of us, like having heard the testimony first, the direct examination, and then more importantly, the cross-examination or trial of those witnesses, is completely reckless. And he's out there like I would have been filing a motion for sanctions against this guy. And I don't know if Yannetti and Jackson did, but like, this is completely inappropriate. And like this is where, if a defense attorney, if they would have come out and done a presser like this, saying that everything that guy just said is bullshit, they would have gotten hauled in front of the judge. And we know that this judge happens to be a very pro-state judge, as most judges are. Like, if you were to do statistically, which I'd love for you to do a little chart for, and just like Google the information in terms of how many sitting judges currently took the prosecutor's track to get on the bench and how many took the defense attorney's track to get on the bench, you'll be stunned to see it is massively in favor of the prosecution side. So many judges are all former prosecutors, which of course, their job is not to be biased, but we are human beings. We are not AI. We are not robots. Whatever you had done for a living, and if you did it for 20 years, it's ingrained in who you are. Like being an attorney, like I always just tell my dad, it's like, well, if I go to law school, my dad would say, I'm a lawyer. It's like I'm a person, but I'm first and foremost a lawyer, and it bleeds into every part of my life. And I was like, well, I'm never going to be like that, man. I used to have these debates with my dad. I'm like I'm going to be a human first, and that's just a job. And then of course, when I started practicing, it does become ingrained into you. You filter everything through the way that you think. You know what I'm saying? And if you are thinking from a myopic, completely subjective viewpoint of a prosecutor, because they are subjective. They can't be objective. When they tunnel vision in on whoever cops have given them as the suspect, that becomes their guy or their gal. And no one else is even a thought in their mind. Whereas with defense attorneys, we have to think of everything else. We're always trying to point the finger at a different guy. You know what I mean? Right. If it's a case where there's not smoking gun evidence that shows that it's our guy, which is the case a lot of times, so yeah. Morning.
To the homeowner and accused him of attacking John O'Keefe as he entered the home. But phone evidence shows O'Keefe never entered the home at all. Testimony from witnesses tell us that 18-year-old Colin Albert had left his uncle's home before John O'Keefe and Karen Reed had arrived outside the residence. There was no fight inside that home. John O'Keefe did not enter the home. Colin Albert, the young man being vilified, was not present when Reed's vehicle and John O'Keefe arrived on the street. This is a false narrative.
Again, with the false narrative.
Colin Albert didn't commit murder.
It's appropriate.
Jennifer McCabe, Matthew McCabe, and Brian Albert. These people were not part of a conspiracy and certainly did not commit murder or any crime that night. They have been forthcoming with authority, providing statements, and have not.
Okay, I want to talk about the forthcoming with authority too, because to me, that's a different thing too. I had it up here a minute ago. Let me see.
It's such a self-serving statement. Like
it is.
This guy going to come up there and say that he thinks that the witnesses are lying? I mean, it's like everything that he's saying has no credence, but the problem is that the public, when they see it, they're going to digest it and take it as fact. You know what I'm saying? When the entire question in this case is whether or not John O'Keefe went in that house.
Yeah.
Like if what the defense is suggesting happened inside that house, of course they're saying that he didn't come in the house. So it's like, that is the entire question about the case. So for him coming out and just making blanket statements that, of course, these people, they would never lie. All right, let's see what you got.
Yeah, like to say that they're being so forthcoming, I think is also misleading to the public, because like when I put together, I went through document after document after document, highlighting and re-highlighting and reading and comparing and charting it out. And when you look at all the different statements that were made, they're not consistent, and they're not only not consistent with each other in a lot of times, but they're like Jen McCabe, for somebody who, and this is why I wish that, like, if they just would have recorded the video, like recorded like with audio or video or anything, any of these interviews, so that way we would know, is this Jen McCabe who keeps changing her story, or is this the police or, you know, prosecution that keep changing her story? We don't know, because they didn't do this the proper way. And that's one of the things that's most frustrating to me. I don't know if I should be frustrated with Jen McCabe, or if I should be frustrated with the troopers who, you know, signed her name on things and or on this report and sent it in, because we never got to actually hear what she said.
Exactly.
So the story that keeps changing, like I'm not going to go, you know, like, you know, threaten her or whatever, like, because I'm like, you know, how dare you change your story? I don't know if it was her. I don't know if it was them.
Exactly. It's like that with anything. Like even if you think about like the Koberger thing, when that PCA dropped and they're talking about Dylan Mortensen and like her statements, and I just kept reading it and I'm like, this doesn't make sense. Number one, I've never heard of frozen shock phase, but my point is that when law enforcement reduces something to writing as to something that they say occurred without having taken a video or recorded or memorialized that conversation in some way so that we can see what was actually said, you're getting the cops' interpretation of what they say happened, and we have no way to disprove it as defense attorneys. You know what I'm saying? It's like, until we get her on the stand. And that's the point of cross-examination. I can't get a police report into evidence. You can't put them in, but you can use them to impeach witnesses. You know, so like when you'll see it all the time in trials, like police reports are not business documents, they're hearsay. So that's why you can never get a police report and put it into evidence for the jury to take back and read. So, but you can use them obviously to cross-examine people, and you can obviously use them to impeach them in terms of if they're making inconsistent statements. Like in what I was talking about with like Dylan, like that's like all the speculation about her, about how she survived, and like she's the one that law enforcement used as seeing a guy all dressed in black with bushy eyebrows walking out at such and such a time, and why the hell didn't she call the police, and why didn't she call 911? Why is 911? You know, so it's the same thing here. You know, when we have no idea what Jen McCabe actually said. You know, all we know is that she allowed for them to take her phone and analyze it. She was not aware, apparently, at the time that Cellubrite existed, and that they were going to be able to extract all of her deleted text messages and all of her deleted searches. Because like Cellubrite, like we learned the hard way on the Garcia case, because they did the same thing with Anthony Garcia when they extracted all the data, because it gets about 98% of what you thought was deleted and off your device is still very much there. Just a little note to all our potential criminal masterminds out there. The only way you can get rid of it is destroying the phone, which in and of itself is indicia of guilt. Like if you start destroying, like a crime's committed, you're like, oh yeah, my phone broke, oh, I lost it, you know, like 2 days after the crime committed, that stinks of like guilt. Like it's indicia of guilt. It's not a good look. So
and I think that even like, you know, the interviews being recorded would have been a huge deal. But even like the reports that they did, like I made a note on this too, because I couldn't believe some of this, like the reports that some of them did, like these were all the reports from like the initial first responder, people who showed up, like the Sergeant Good and Patrolman, Lank and Mulaney, all them. So that's what that colors. But then you have like the different ones that were written. Okay, so Nicole Albert was interviewed on February 3rd, but the report wasn't done until February 23rd. So that's almost 3 weeks later that a report was done. Okay, but what happened in between those? Was the report written right afterwards? Where are the notes from it? How did you get this report that was sent 3 weeks later? What happened in between there? And like, those are the things that I think are so crucial and important, because we don't, like, for him to get on here and say they've been so forthcoming. Maybe they were. Maybe they have all been crazy supportive, like, this is what happened, this is what happened, and things are getting messed up on this end. Or maybe the, officers and whoever have done this have been, really detailed with stuff, and they keep changing their, stories. Like, but without having something to show us about who actually said what and when, we don't know. And I think that's a huge problem.
Exactly. You're just getting the cops' narrative. Like if they don't have recorded interviews, we'll have no way of ever knowing what was actually said, and which is exactly what your point is. And just so people understand, like, my job for the past 20 years has been just digging into police reports, and so that people understand this, they are not written contemporaneous to the investigation. Like, they are typically written weeks, sometimes months after whatever occurred. And if they didn't, like you're saying, if they didn't take a video, they're writing their report based on what their notes are, and that's it. And if you've got a situation which has been suggested here, that there's been a cover up, then you've got suggestions being made by higher ups in terms of, because every police report, if you read them, is always signed off by a superior officer. So whenever a cop writes a report, they'll sign off on it, and then it's reviewed by a superior officer. And at that point, then things get tendered to the state. You know what I'm saying? So it's like, but like I just don't know if people are under the impression that cops are writing these reports like that. Like the night that they went and talked to Jen McCabe, they went and typed up the report. Hell no, that is not what happened. I guarantee it. It's like, that's just not how it's done, because they do the investigation and they understand. They unequivocally understand that these police reports are what the state and the defense rely on completely in terms of trying the case. It's all we have are the police reports, and you can see how powerful they can be, and at that point, like to your point, like, for not every interview to be recorded, to me at this point in this day and age with the technology that we have, with cops just being able to record it even on their phones, is ridiculous.
Yeah, because even the smallest thing, the smallest detail has been known to break a case. Just the smallest little thing.
The devil's in the details. The devil is in the details. The devil's in the, my cleaning woman's vacuuming. Sorry.
Oh, it's fine. I don't hear it, so you're fine. But yeah, I agree.
Not engaged in any cover-up. They are not suspects in any crime. They are merely witnesses in the case. To have them accused of murder is outrageous. To have them harassed and intimidated based on false narratives and accusations is wrong. They are witnesses doing what our justice system asks of them.
Okay, I will say this, though. I agree that people should not be harassed. I agree with that. Like, you can't just go around, harassing people. I agree with that. And he is, he's saying they're not a suspect. Okay, legally, in their eyes, they're not suspects. So I get that. So I do think that, like, no matter what theories we have come up with, or no matter what theories defense has or anybody else has, I don't think it's okay to, like harass people. I do get that. But I feel, my personal opinion, he's using this as an excuse to tell everybody what his truth is, what he wants to be the truth.
Like that's the thing about Turtle Boy, is like, he's getting what he believes is his version of the truth, which is the defense's theory out there. He's doing it super aggressively, which my thing is that he's like kind of undermining what I think is a very strong theory by being so aggressive, by like especially with these witnesses. Like once he got it out there, just let it fester, because it was super compelling when he's just like just all over these people. And like when he was screaming at the one cop, like with the bullhorn, like like you worry that he's so aggressive with it that in and of itself is undermining what the message is, because I mean, there exists such a thing as there's too much. Sometimes, less is more a lot of times, just planting a seed is a very effective way to get people to start thinking about something. When you start smashing them over the head with it, people become resistant to it. You know what I'm saying? That's human nature. Plant the seed, and the seed was planted. And I give him a ton of credit for doing that. He then started taking, like a Captain Caveman club and smashing people over the head with it, which then bolstered the pro-state, pro-police side on this case to saying, look at this guy. This guy, like how can you, like, it became about Turtle Boy as opposed to like the facts became muddled in terms of, what the underlying facts that he's screaming about, to where he's then become a part of the case in a weird collateral way, which, I mean, that's kind of my whole thing with it, because like everything he's saying in terms of his position, I agree with, I mean, and it's just his approach is, it's tough. It's tough because it's super aggressive. You know what I mean?
Yeah. And you're right. That has become kind of muddled with things. And, one of the reasons that I called the podcast Conspiracy in Canton is because both sides are claiming conspiracy. Like you have, one side is saying this is a conspiracy to frame Karen Read to, get this family out of trouble. The other side is saying they have this conspiracy to, use people like Turtle Boy or, whoever in the defense team to spread, this, off the wall, wild narrative because they don't want the truth out or whatever. Like this is all the defense's, plan to make everybody think that this is a cover up. So like and that's one of the things that I think has been so interesting about this case is that, and that's why I called it Conspiracy in Canton, because both sides are blaming the other for trying to change the public opinion. And I think that makes it kind of gives it like this whole new level of like circus.
Right.
that has made it so
that's
crazy.
The thing. It's like the case itself has gotten lost, much like Delphi, like in the circus. You know what I mean? Like we're like you almost forget that there's like a victim here. Like John O'Keefe is like the guy that we're all fighting to get justice for. But, like everybody understands, like you only have justice when the right person or persons are convicted of committing the crime, which is what we're trying to get to here, you know? And again, and you said it, you nailed it when you were talking about like right before I came on, you're like, look, like, of course there still has to be a trial. Of course they still have to vet the evidence, but like, I can tell you based on the evidence that has been put out there, it reeks of reasonable doubt. And it does. Now, does that mean that at a trial that the state can't come in and tighten up everything and they put on some amazing expert who can really break down how that search at 2:27 in the morning about, how long to die in the cold didn't actually take place at that time, and that they can give me a reasonable explanation of what those injuries on his arm were, and that, the tail light was not broken or was broken at the scene and they can prove it, and it's like, my whole thing with the conspiracy thing wasn't the only reason that I wanted to get you off that word was because of Coffindaffer. Coffindaffer.
Oh, she took it and ran with it.
Oh my God.
Yeah.
She just kept puking out. Oh, so you believe it's conspiracy. So now you have to have all these people. I'm like, oh my God. I'm like, no, you don't. You need two cops. You basically need two cops to make it a conspiracy. That's why I'm like if you've got a situation where like a conspiracy to me is where people are in agreement to, and I always go by the legal definition of it, that it's where something is planned ahead of time and it's multiple people that are planning to do it. I think that this thing happened spur of the moment. And I think what happened is that they were trying to cover up what happened. And, and they came to the point where like, all right, look, dude never came in the house. That's our story. And we're sticking to it. It's pretty simple. It's a pretty simple concept. yeah, she may have dropped him off, but he never made it into the house. That's what we're all saying, and we're never changing our story. Agree. You know, and whoever was left at the party at that time said, "Oh, okay." You know, because like even if they would have just pummeled him, and like it's still an aggravated battery with the injuries he had to his head. You know what I mean? Then to drag them out, and these are cops; they can't afford to get a aggravated battery. It destroys their career. So like even before it gets to the point where John O'Keefe has passed away, it's still a problem. If something happened in that house, if it's the kid, like who everybody, what's his name? Colin? Is that the kid's name? Yeah. I mean, if something went down with Colin, the kid already had some legal issues. If it's him and something happened in there and he got a little too aggressive and like my concept is he might have taken like a weight plate, like one of the little round ones and bonked him. Like that wound on the top of his head, like in the kind of the back right behind the crown, is indicative of me, not of him being hit by a car where he has no evidence whatsoever. Like, if somebody can explain to me in the chat how they think that somebody could get hit, and I don't care if it's 5 miles an hour. I once hit a deer going like 7 miles an hour, killed the deer, and destroyed the front end of my car. All right. So cars are very heavy. Okay. If he was struck anywhere on his body, and he would have had to have been, like if you're just looking at a Lexus SUV, he would have had to have been struck somewhere on his body. Show me the bruising, the contusions anywhere on his torso, on his leg, anywhere. They don't exist. Like, so that's when Coffindaffer's coming up with, oh, he dropped his glass and was bending over to pick up his, I mean, what? Are you kidding me?
And to be hit by a car, and again, like I'm not pretending to be a medical expert, but I'm saying like as a potential purple, candidate, I would look at that and say, okay, all of everything that I've ever known about somebody getting hit by a car, there is, like you said, like there's bruising and there's torso damage and there's all these things. It's not head, and like this is not where you get hit by a car.
Exactly. That's what I'm saying. Where's the contusions? Where is the bruising? Anywhere on his body? Like, if that existed, I'd be like, all right, well, he's got like this huge contusion like on his ribs that looks like maybe he got hit by a car. The fact that doesn't exist is extremely powerful evidence to the fact that I don't believe he was struck by the vehicle. I mean, it's like, aside from the wounds that he does have, really looking inconsistent with him being struck by a vehicle, he doesn't have the wounds that you would expect somebody to have if they were struck by a vehicle. That's more convincing to me than speculating on what the wounds that he does have came from. The fact that the evidence that he was struck, any evidence on his body doesn't exist, is more powerful than the evidence of his actual wounds. To me,
Yeah. And that was one of the things too that I noticed that I love a chart, I love a diagram, but one of the things that I did, like the car movement, which I saw Brian is in here and said that I guess they filed a motion yesterday, which I have not even seen, that where they basically got rid of this whole thing. So I guess they finally, maybe they realized it doesn't make sense. I'm gonna have to pull into that. So thank you, Brian, for letting us know that, because I haven't seen it. But this is one of the things I did with that, because I was looking at that and I was like, all right, let's map this out. And the way that between the location of the phone data and what their theory is about the 62 feet and all that, she would have had to have been, if they said that she drove at least 62 foot forward and then reversed 62 foot at possibly 24.2 miles per hour. And then she hit John and then the car continued in reverse. So 62 foot would have put her in front of the neighbor's house. And that would have been past that big group of like trees where that flagpole is and everything. And then she would have ended back here. Now, keep in mind that Ryan Nagel was right back here it was Ryan, Richie, and Heather that were in that. And then Julie had come out to talk to them. So you got four people.
So he was coming to pick up his sister, right?
His sister, Julie, yeah.
Okay.
Yeah. So they're parked right here. He said they pulled up and they're like right on the side. Now, there are a couple of the different statements that say that when Karen first pulled up, that she pulled up like in front of the house and then she moved more towards that, like edge of the property, like more over this way. According to this, she would have had to have driven 62 foot forward and then back and then kept going in reverse. My only thing that keeps popping up in my head too, when I mapped all of this out, remember well, I don't know if I ever posted it because it's about the time I started getting sick again, but I'll have to look at that and see if I posted it. But there's I mapped out a lot of the map data when I was comparing all the cell phone evidence. And there's a time too that it shows that she took a wrong turn and she pulled in somewhere and then backed out and then came back. And then that's when she came to the house. And I was thinking, I was like, you know, is that what they're seeing as the 62 feet, you know, reverse? Because there's like something isn't adding up with this,
Right.
you
Why-
know?
Right. Like, why would she go? So which house had the Ring camera, Brandi? Was it the one across the street that we can see here, like to the right of your name? Like is that one there that we didn't get the footage of?
Yeah, no footage. They said there was no footage of evidentiary value or whatever like that. There was nothing that was on there, which.
Did the defense ever get to see that?
Mm-mm.
So wait, the state just said there was nothing of evidentiary value, so they didn't.
No, I think it was if I remember right, y'all. Like I said, my brain's not as sharp as it normally is right now. But I believe it was the homeowner that said that. That was like, oh, there's nothing on there. Like, you know, we didn't see it. But but correct me in chat if I'm wrong on that. But that's the way I remember it. I'd have to go back and look at my notes. But that's what I remember. But yeah, again, I think that's one of those things that's not for the homeowner to decide. That's for you subpoena that, you get it. And then could you imagine like having, you know, evidence of exactly how that man lost his life and a homeowner being like, there's nothing on there. You're good.
Crazy.
You know,
no
big deal.
So the immediate thing that I want to think about is these two are neighbors. They've lived there forever, presumably. How close is this neighbor with the Alberts?
He's a Canton deputy.
I mean, come on, dude. Like seriously, like that's the kind of thing when you hear it, if it doesn't make you go, then I don't know what to tell you. Like it's sus. It's super sus.
Yeah.
Like to me, like the fact that exists in the world, that this guy had a Ring camera and he like independently decided that it had no evidentiary value without turning it over is incredibly suspect to me. Incredibly. Because we all know Ring cameras catch everything, you know, at least within its lens. Yeah, like how could there not be anything of evidentiary value? Like if she drove, if that in fact is the house, the state's theory is that she drove 62 feet forward, 100% you're going to see her vehicle pulling forward and then going in reverse. So how can that be the case that there's nothing of evidentiary value?
Yeah. Yeah. I agree. It's
crazy.
The autopsy of Joan O'Keefe was conducted by a forensic pathologist from the Office of the Chief Medical Examiner. The doctor found that the injuries that left John helpless in the cold were not a result of a fight. She further found.
Okay, again, this is one of the, because there's two different medical examiners who have come up to two different conclusions on this. So again, he's presenting one side, and this is not in trial. We're not in trial here. This is, you know, I again, and like I said, I'm not an attorney, but to me, this doesn't seem
found.
And beyond that, like just so people understand, when cops are going in there, and there's always law enforcement that sits and observes the autopsies. Okay, so and remember, the ME wasn't there. Okay, they were not at the scene of the crime. So when they come in, the cops are suggesting what they believed happened already before the autopsy even starts. And understand, a medical examiner, again, is a state employee. They are paid by the state. So when cops are coming in and they come in and they tell the ME their theory of the case, again, we're talking about the planting of seeds.
Right.
That is in the ME's mind. Okay.
Right.
And so like an ME coming in and determining that was the cause of death and it's not consistent with the beating, like at that point, you know, I mean, like, have we seen the reports? Like, have we, like, because I know that, like, Yeah, I've seen autopsy pictures,
Uh-huh.
but I haven't seen the reports to see if the ME articulates that I don't think any of the injuries are consistent with there being a physical altercation. You know what I'm saying? I'm
Yeah.
dying to read those things. Like if they're out there, if somebody knows if they're out there, I'd love to know if they exist.
I haven't seen the full reports. I've seen parts of them referenced in some of the different, documents that I have. But yes, Brian said there's an email where the medical examiner asked for the theory before writing the report.
That's exactly what I'm saying, Brian. Thank you for that.
Which in any normal case might not be,
Always.
something that you would look twice at and think like, oh, but when there's two such different theories, it's like, okay, if I'm a medical examiner and I'm looking at this, I'm not going to be like, oh, well, here's scratches, so it must have happened by this. Like I can understand a medical examiner say, okay, so what are we thinking happened? And then they can look at these and say, okay, this is consistent with this, but this wouldn't be. So this is this. Totally.
In most cases, when it's getting to the point where we're watching it, you're talking about shootings, stabbings. You know what I mean? This is not that.
Right.
This is like open to interpretation of how exactly he died. It's like there's not evident wounds of what killed him. Like I still don't know. Like I guess it was hypothermia and the wounds themselves. I mean, if he was knocked out
and hypothermia, I think were the contributing factors. I think
but like the blunt force trauma,
on his head.
Yeah, I'm not a doctor. I don't know how long you're going. Like to me, it's like he was hit so hard on his head that it knocked him out for a really long period of time to where he's like, and you've got to obviously incorporate the alcohol consumption, like with being passed out and knocked out combined. Back in my drinking days, when I'd tie one on, man, I was dead to the world.
Yeah.
Until the following morning, I'm like, I'm just getting out.
Right.
So it's like when you combine those two things, a night of drinking and then blunt force trauma to the head, you could see why he'd be knocked out cold. Where I'd like to know, because there was no actual. Like, I don't believe that his skull was fractured, correct? Like, we have the big laceration.
There was the laceration. I thought they said he had a skull fracture or contusion or something, and that's what caused the there was something saying that's how he got his black eyes, was because of that or something. Which,
yeah, but is that enough to kill you? Again, I'm not a doctor, so but that's the question I'd be asking. Is that kind of like my point is I think that he died of hypothermia. I think that that's what killed him. I think that the fact that he was knocked out was a contributing factor, but I don't think that the hit to the head is what killed him.
Right.
You know what I mean?
Yeah. That's the way I understand it too. Like, because, think about like if something had happened and then he, immediately got medical attention, then it would have been a totally different story than, this happening. And,
Nancy Archer saying multiple skull fractures, screaming it.
Multiple skull fractures. Yeah. But that was one of the things that they said was the contributing, or what caused the black eyes, because that was one of the Commonwealth's things too, is that a lot of the stuff that I was saying is like the black eyes weren't from a fight, they were from the skull fractures, or whatever. And which I'm not a doctor, I don't know if you get black eyes from a skull fracture back here. I don't know how that works, but that was the way they explained it. But then there was like bruising on the knuckles and stuff. Like,
I mean, when I looked at the and again, I haven't read the ME's report or an autopsy report. Like, all I've seen are the pictures, and I've been in fights. I've defended clients that have been in fights. I've seen thousands of pictures of people that have been in altercations. To me, again, I'm not a doctor, I'm just a lawyer. They looked consistent of a fight. And do I know if somebody gets their nose broken that they'll get two black eyes? Yes, that certainly happens. Is it possible, I suppose, if like a contusion in the back of the head? So a couple of people saying there were multiple skull fractures. It then becomes an issue of to what extent. Like, are we talking about where the skull was fractured to the point where he's got skull bone going into his brain? or are we talking about hairline fractures? I mean, like there's a delineation between the type of fractures, right? So,
Yeah.
which is why I asked. I didn't know.
Dino Kelly is homicide detective in Las Vegas. He says
Hey, what's up,
our
Dean?
best medical examiners won't even talk with us until after the autopsy. Even then, our only questions are cause and manner, objective analysis. See, that's
Man,
the
I
way.
love that. That's
Yeah.
awesome.
Yeah.
That's how it should be. That's
Yeah.
100% how it should be.
Yeah.
Because then you avoid this.
Yeah.
You know, like I love that. Like
Yeah.
they do not do that in Illinois. In Illinois, their cops are all up in there, like just
Yeah.
watching the entire thing, you know, asking questions during the autopsy. You know, it's like, so
Yeah.
what is this? What do you think this wound? You know what I mean? It's like that's good to
Yeah.
know. I did not know that. Thanks for that intel, Dean.
Did you watch the Thomas Randolph trial, didn't you? The widower.
I did.
Dino Kelly was the lead detective at that.
Oh,
He's-
nice. Nice.
That's his trial. He's
I
responsible
think
for
I
Tommy being
came
in
on.
jail.
I think I came on with you during one of the
I think
days.
so.
Yeah.
I think so.
That was a great trial.
It was a great trial. It was
So good. So good.
He's a character.
And it was like I was on when his brother was on court TV, and he like started like he wanted to have a rap career. So I was on. No,
that was Travis. That was Travis Rudolph. That's Thomas Randolph and Travis Rudolph were two different.
Oh right, yeah. Rudolph was down in Florida, right?
Yeah.
Okay.
Thomas Randolph is Las Vegas. He's the one who had the 6 wives. 4 of them ended up dead. And this was his third trial for
super creepy looking dude. Okay.
Super.
Yeah. All right, I'm with you. I was definitely confusing those two. Definitely.
I've said the wrong last names on them. I can't even tell you how many times. Like Travis Rudolph and Thomas Randolph. I have
very different. I apologize to Travis for confusing the two. Though. One guy was acquitted and should have been. The other guy was just a disgusting pig.
Yeah.
So,
yeah.
Yeah. That guy was the worst.
He was. Oh God, he was awful.
Tommy.
Tommy.
Yeah, exactly.
Not an animal attack. A grand jury of everyday citizens heard the documented evidence and testimony before making a decision. The subject of that murder indictment enjoys the constitutional presumption of innocence. Why should the witnesses who have committed no crime be afforded less by members of the community? They should not be harassed for telling the government what they heard or saw. I'm asking the Canton community and everyone who feels invested in this case to hear all the actual evidence at trial before assigning guilt to people who have done nothing wrong. And certainly before taking it upon yourself to harass citizens who evidence shows have done nothing in this matter but come forward and bear witness. We try people in the court and not on the internet for a reason.
Okay, but we try people in court and not on the internet for a reason. I agree with that. But isn't it a little ironic that he's releasing a video about like the internet? We don't try people on the internet, but let me release a video on the internet so that you can all hear what we're saying.
This is like the most self-serving thing that a prosecutor can do. Like it's like the prosecutor in that Garcia case they handled in Omaha, the quadruple homicide. Our client was a doctor. Like the prosecutor in that case did something very similar. We always referred to it as the fireside chat, where like he had the news people come into his home and he's got a crackling fire in the background and he's sitting in his chair. He might as well have like fired up a pipe, he's just sitting there pontificating, poo-pooing everything that we had been saying. Cause that was another case. It was like heavy press and they were leaking the information out to the press. And they had one dude in particular with the Omaha World Herald that was their lackey. So whatever the state wanted out there, he got it out there, and it was like us trying to, there's a rule, an ethical rule called the safe harbor rule, where we're allowed to make a statement to the press. And there was no gag on that case. So theoretically we could have gone out, but there's evidence that that hasn't been made public that can only come from one source. And when that ended up in the newspapers, we're like, my God, they're trying the case in the press. It's ridiculous, and they're convicting them in the press. And so when we'd come out and make statements like Allison got booted from the case because we tried to come out and even the playing field because we had said our DNA expert has excluded our client from the DNA on the door handle from another doctor that wasn't even killed. Like, it's a whole thing. But yeah, it's like the same thing. It's like, it's devastating to a case. But like in this case, that's where the Turtle Boy factor comes into play. Like, he's so loud, so aggressive that like he's offsetting to a certain extent what this dude's doing right here. You know what I'm saying? And he's doing it in lieu of the defense having to go out and do it. Like, they probably love him. Like, if I was a defense attorney, they'd be like, well, I'm not going to align myself with him, but I love everything he's doing. You know what I mean?
Yeah. Yeah. Kind of like, because in a way, it's almost like, fighting their battles without them
having to get their hands dirty. 100%.
Yeah.
Yeah.
It's like, I could see that. I definitely see that.
Yeah,
The
definitely.
internet has no rules of evidence. The internet has no punishment for perjury. And the internet does not know all the facts. Conspiracy theories are not evidence. The idea that multiple police department, EMTs, fire personnel, the medical examiner, and prosecuting agencies are joined in or taken in by a vast conspiracy should be seen for what it is, completely contrary to the evidence and a desperate attempt to reassign guilt. Michael Proctor, the state police trooper, being accused of planting evidence outside 34 Fairview Road, was never at Fairview Road on the day of the incident. Proctor and his state police partner traveled together the entire day while other officers were processing 34 Fairview. Trooper Proctor was not there and did not plant evidence at 34 Fairview Road. In addition to having no opportunity to plant the evidence, as has been suggested, Proctor would have no motive to do so. Trooper Proctor had no close personal relationship with any of the parties involved in the investigation and had no conflict. And he had no reason to step out of this investigation. Every suggestion to the contrary is a lie. This should be seen for what it is and not used as a pretext to attack and harass others. What is happening to the witnesses, some with no actual involvement in the case, is wrong. It is contrary to the American values of fairness and the constitutional value of a fair trial. It needs to stop now. I am releasing this recorded statement rather than holding a news conference because my remarks need to be so narrowly tailored to the issue at hand while the prosecution is pending in Superior Court. But the message is the same. What is happening to these innocent people, these witnesses, is wrong and it needs to stop.
So,
wow. I mean, there you go.
Yeah, I think that there's so many things that are wrong with that. And there's so many issues that I have with him doing that. And, I think that the only thing that anybody should care about in this is the truth. There are going to be things that we all interpret differently, but you put all of it together and come up with your decision. And I think that, to me, I think you nailed it when you said that that's like he's doing his closing arguments instead of, actually addressing anything. So it's been a wild ride so far. And it looks like they're going to stay on track for us to go to trial in March. So,
yeah, I mean, to me, and like typically when you're closing in on trial, which they definitely are, and like, just so people have an understanding in terms of trial prep, especially in a case like this, like 3 months is the blink of an eye. I mean, like the blink of an eye, like for lawyers trying to prepare for a case like this, it just goes so fast. And the point being that if we have not seen a motion to continue the trial at this point, I put it in the chat earlier before I jumped on. I'm like, it seems like this thing's actually going to go, because the closer you get to trial in terms of the judge scheduling, and like I saw people when like the judge wouldn't reschedule when they said that they had a trial that day, like the next day.
Yeah, they were both in trial.
Which is like, like that's normal. Like, judges are because remember, they have a full docket. They've got things, they have their own docket, they have their own trials, they have their own cases. So when they're looking at it, they're trying to fit it into a date. And it's like, well, you could just appear via Zoom. So I didn't take anything from that. But what that tells you is that this judge, if they come at the 11th hour with a motion to try to continue, they better have a damn good reason, like either side. Because if they're not giving her the time to say, okay, well, I've got to look at my trial schedule and see what I've got going on. Because like I said, I mean, she's got a full docket full of other cases that aren't Karen Reed, so, and she's got to try to fit things in. And, you've also got this issue. Does anybody know what is the speedy demand? Was there a speedy demand on this thing, like a speedy trial demand in this case, or no? Does anybody know?
I don't think so. I think I don't. I mean, I'd have to pull up my notes.
It seemed like, so when was she arrested? It seems like not, because the case has been going for a while, right?
Yeah. This is, let's see. Let me share my screen again. I have all
Brandi, I just text you my LinkedIn or my link tree. Can you put it in the private?
Oh, yeah.
Holly can throw it up.
Yes.
Just, yeah, I do have a YouTube channel. And my wife, who's way better looking and way smarter than I am, who's also a criminal defense attorney, is my partner on there. So if you like strong, powerful, brilliant women, like our friend here, you'll probably enjoy our channel. Like, I probably talk too much. Like, everybody's like, Bob, shut up. So you can tell I talk. I'm definitely a talker. But yeah, no. So we just passed 10K today. I was very excited. So
yay, congratulations. You're moving up fast. That's
awesome.
awesome.
I mean, man, it's like, because like my thing is my podcast. Like that's my labor of love, which, if you guys like podcasts, true crime podcasts, like check it out. It's pretty good. I'm pretty proud of it. And we've been doing that for 2.5 years. But then I finally was like, I want to start a YouTube channel just because like I'm doing something different in the sense that I'm kind of like, we're talking more about the legal side of stuff, a little bit like Lawyer, except like, I don't know that Peter is actually a criminal defense attorney. I think he's more of a civil guy, but he's got a wide knowledge base. You know what I mean? So he knows a lot about like all the areas of practices as I do too. But I typically stick to like what I did practice wise, which is criminal defense. And I did some divorce, but I try not to talk about that because it's very, very depressing. Divorce law is the worst. It's so rough.
I can imagine.
Oh God, it's the worst.
All right, I'm pinning your, chat moved. I'm pinning the link tree at the top of the chat too. So anybody that,
cool. Thank you.
I thought
come sub. Like we're deep into Delphi. Like I am knee deep in that case. I had to take a step back just for a minute. Fortunately, there was kind of a little break because that case. Have you followed the Delphi thing at all, Brandi?
Yeah, a little bit. I missed so much of it for a while, and then when I went to CrimeCon, which we saw each other at CrimeCon.
Yep.
When I went to CrimeCon, I listened to that on the way home. I kind of binge listened to all of the stuff going on with the.
So insane. It's so insane. Like there's a lot of like factually, it's obviously a much different case, but in terms of just the craziness that is like overtaken that case. It's like you never want to lose light, or the fact that two beautiful little girls were killed, because ultimately that's what the fight is for getting them justice. And it's like,
right.
So much shit is going on with this that it's like, it's like you worry that concept is getting lost. And, but like when you're talking about the trial phase, it's like really the thing that is most important at that phase in terms of getting justice for the girls is the rights of the defendant. And are they getting a fair trial? Because if the defendant doesn't get a fair trial, they're having to do the whole thing over again. And the families are having to sit through the nightmare of having to rehash for weeks or months the worst day of their lives all over again, and it's like no one wants that. I mean, everyone on both sides of the aisle wants to get it right the first time. And like any prosecutor worth their salt will 100% say, yeah, absolutely. Like no one wants anything getting overturned on appeal, which is always always the concern. That's why you want the trials handled properly on the front end, because everything that's happening now in this case or in any case, whether it's pretrial motions, is always a potential issue for appeal, so it's important when the judge makes rulings on these pretrial motions, because, if you're going to argue, if you get a conviction down the road and the defense can say, okay, well, the judge, it was beyond their discretion to rule this way because of this law, and that law, and if the appellate court agrees and they say, okay, well, you shouldn't have admitted that evidence at trial was incredibly prejudicial. We're going to kick it. And we think that it affected the jury in terms of a verdict, I mean, that's always what it is. So yeah. That case is crazy. It's so crazy.
I binge listened to your stuff when that, when those documents dropped, because it was right after or right at the time we were at CrimeCon, right? That all that, the stuff came out about the Odin, stuff, whatever.
Right.
I think it was, so if I remember right, I think I was like on the way home when I was listening to that, or maybe it was on the way to doctor's appointments. I remember listening to it when I was on the way, like on long trips. So it may have been to my oncologist because that's 2 hours away. But regardless, I sat there and like binge listened to all of your stuff on that. And one of the things that, and I've told you this before, when you and I first became friends, I was like, I was one of those that like, I don't like defense attorneys, because I had that in me. Like, I want to see bad guys in jail. Right. And it wasn't until I started like, like getting in, and I mean, obviously there's some exceptions to that, like there's always going to be exceptions, but there were some things that you were pointing out on your podcast that like, and not just with Delphi, but like in your other ones, like that I'm like, I was gritting my teeth listening to you, but I was like, he's right. Like I think it does a good job at opening up, perspectives to like, to really go into things with a, open mind and fair. And when I was listening to the stuff that you were saying about the Odin stuff, I was sitting there listening, because anytime I listen to somebody else's perspective, I try to put aside all of my preconceived everything and truly understand it from the perspective that I'm listening to. And I did that when I was listening to yours, and I was thinking, okay, so let me go into this thinking, like, that we know nothing about anything. This is an innocent man. And let me listen to, what they're doing to an innocent man who, whatever. And I listened to it with kind of like that lens on.
Blank slate, which is
it's terrifying to think that, like some of that stuff could be, true. Like that case, when I listened to all the Odin stuff, like that's when everything all of a sudden became, I was like, this is going to end up as like, I originally thought a movie, and I was like, it's too crazy to be a movie. It's going to be like a mini series.
Sure.
Yeah.
Like everything that has happened subsequent that, like you've got like this sideshow, which is the defense attorneys being removed from the case by this judge forcibly, and it's like, I've been at war figuratively, because the prosecutors podcast, they're my friends in real life, but like we're both on very opposite sides of this. And like, but I don't get mad at people if they have the opposite opinion of me. I love when people want to engage in debate. That's what I do for a living. Like I never take offense if somebody says, I think you're wrong and this is why, as long as they can be articulate and civil about it. Like I always encourage people, like on our YouTube channel or in our chats on our Facebook page or anywhere, like I'm like, have at it. Just be kind, be civil. We're allowed to disagree. I mean, like that's what is the fabric of our country, is disagreement. I mean, like without us, if we all agreed on everything, nothing would ever get fixed. Nothing would ever change. If we all, could you imagine? Like if everybody agreed on like when they were writing the Constitution, it would have been a big steaming pile of turds. It's because these guys were battling over, what it should say and how it should really, I mean, like we need disagreement. Disagreement ultimately is what creates ideas and concepts, and it makes you think about other things and the other side of things. Like, so everybody should always be open to debating and listening to argument. Like no one I don't pretend to know the answers like on any case, because I wasn't there. Yeah. You know what I mean? It's like, all I do is give my interpretation of the facts and the evidence, and that's it. My opinion is my opinion. And like, I can never say anything definitively because I wasn't there, like in most cases, as a trial observer, I mean, most cases are built on circumstantial evidence, and circumstantial evidence everybody's like circumstantial evidence. Not everybody. I think people are starting to understand that most cases are built on circumstantial evidence, because direct evidence is hard to get. And if direct evidence is like an eyewitnesses suck.
Right.
Like they
Yes.
just do. They're not reliable because of the fact that they're humans. Like if you're an eyewitness to a shooting, you're not standing there watching carefully when somebody's pulled a gun out and shit. Like you're ducking because you don't want to die. Like that's like, I'm like, oh my God. If I heard a gun, like I'm on the ground. I don't know what I saw.
And we see that in cases so many times too. Think about how many times they're like, okay, well, do you remember on this date when this happened that you said this instead of this? And like, there's always going to be things that, like human memory is going to be, like skewed in certain ways. There were some things that you will remember very specifically, and there were some things that will get, twisted. So I get that.
Especially like if you're in a situation, say for instance, when you observe something, like you happen to be somewhere at a time when something occurs and you don't even know that anything occurred. So in your mind, you have no reason to commit it to memory, which is the case most of the time. Like say for instance, you happen to be walking down the street, 10 minutes before a bank robbery occurs. You're just walking and, you're looking around, people watching a little bit. You'd look across the street and then it comes out that there was a bank robbery that took place 10 minutes after you were in that area. And the police come and they say, hey, if anybody was in the area, we need to talk to any witnesses. And then, so that person who was walking that day, just making observations, but not knowing that they needed to remember anything, is then contacted by law enforcement, or they reach out to law enforcement. Hey, I was there. And they're saying, okay, well, can you describe any of the vehicles that you may have seen parked around the bank that morning? And the person's like, man, maybe, because you just at that point, you don't know that you need to remember something. You know what I mean? Like, think about how hard the game of like concentration is, like where you're flipping over cards and trying to remember. But like, just think about that in terms of your memory. And just, so it's like they're just not reliable witnesses, So circumstantial evidence is incredibly powerful, I mean, and it is. And that's what most cases are built on. So, and this case is no different. And it's like, man, it's like, I just love what's going on in the true crime community, just in general. I just love like that these, like your channel and just channels that have popped up where people just love what I love, which is the legal system. You know what I mean? It's like, it's so different. It's like, it's so new. It's so new,
Yeah. It's definitely interesting to watch. And there are some parts of it, they're so frustrating. Like some of the pretrial motions and stuff that we had talked about earlier, where, like there's some things that happen where I'm like, no, let the jury see that, but even when you understand why certain things are, the way they are, some of it can be really frustrating, but it is really interesting to watch and, to watch the whole thing
unfold. And that's what I started to say earlier. Like, I love the fact that they're starting to, because if you think about it, and you've probably been watching trials forever, but think about how rare it was for them to ever show like pretrial motion phase.
Right.
Ever. Yeah. They never did it. And I'd always be like, oh my God, that's where the war is. That's where we're hearing about the evidence that you won't necessarily hear at trial. Like in cases where stuff is not admitted that exists, but wasn't admitted for this reason or that reason. And it gives you the context of like, oh my God, if they had admitted that evidence at trial, like that would have changed everything, in
like
terms
the Melly
of
trial,
opinion.
for example.
Yeah, exactly. So it's like, that's why I'm always saying, like, if you really want to watch the nuts and bolts, the guts of a case, you have to watch the pretrial motion phase. Because frankly, those are the most fascinating legal arguments where they're really kind of getting into the constitutionality of the stuff in terms of admissibility. And like, it's super interesting stuff. And I love that people like just gobble it up, it's so cool. So, hey, before we jump off, I know there were a few questions. Wrestlers, I see you. I love you. Thank you so much. I appreciate the love. Ned, thank you very much. I appreciate that. All the kind words from all of you guys that are giving me love, man. I beyond appreciate it. It warms the cockles of my heart. It really does. It really does. So there were a few people that had questions, Brandi, and I think so one of them that I saw was, does the defense have the right to get all of the evidence. All right. So what we have the right to get is all of the evidence that the state intends on presenting at trial for certain, like all of that. But in terms of us being able to conduct our own investigation, which is our ethical duty, like we have to conduct our own investigation. We have to dig into the case. Now, we don't have law enforcement at our disposal like the state does. Like, I mean, when you're talking about the battle and who has the resources and the power, it's always the state. It's always an uphill climb for us as defense attorneys. Like, we'll use private investigators. You know, we'll have PIs that go out who are typically former law enforcement. Like our PI that we used forever until he retired was a former law enforcement guy. And so, you know, like, you need to always be worried about the fact that the state might be withholding evidence in terms of Brady material. So you ask for everything. Like, typically we'll get everything. Like, if I'm getting all the police reports from an entire investigation, if it's an investigation that went on for years, I'm going to have a ton of stuff that is completely irrelevant, like not relevant to the case, because I'll get reports from every single witness that they've spoken to, including witnesses that may not have anything to do with the case, may not have any knowledge about anything, but I'm still reading through everything because I'm trying to investigate. I'm trying to see if there's an alternate theory. So yeah, typically we get everything. Obviously, if they have experts that have tendered reports to them, they have to turn that over, especially if it's going to be introduced to trial. Essentially, the thumb rule is if they're going to introduce it at trial, they have to give it to us. They can't blindside us. There's no trial by ambush. And that goes the same way for us. Morning, Bubby. My kid's still on Christmas break. Can you believe that?
Aw.
She's so sweet. Oh, she's going to come over here. You can jump on here. Sometimes I'm very, she's a total ham. This is Scarlett.
Oh, hi, Scarlett. Oh, I love that name.
Yeah, she's a good, what? Okay. Oh yeah, your hair's got bedhead. Yeah, this kid like rolling out of bed at 11:23. Like, what 11-year-old does that?
It's because I went to bed super late.
It's true, you did. So yeah, so that's kind of the long and the short of the discovery. Now, the other thing that I wanted to, and I saw somebody ask, was like, I jumped in right when they were discussing the issue of whether or not Proctor's DNA was going to have to be turned over. Now, that is unusual. Like you're typically now, like, what they'll do sometimes is they will get officers that were processing a crime scene. They will get their DNA samples on file just in case, because look, we're all humans. Cops are humans. You know, they're not robotic. Again, like, there's going to be cops that inadvertently don't put footies on or may touch something that they shouldn't have touched when processing a crime scene. So they'll typically get profiles from the cops just so they can eliminate them if they do have an unknown sample that's showing up somewhere. So, but in a case like this, where the defense's theory is like, look, we are suggesting that the taillight material was planted and there's an unknown DNA profile on there, we think it was Proctor. And we
Too
think
unknown.
Yeah, and we have the right to profile. That's why I was asking in chat, because I don't know. Does anybody know out there, or do you know, Brandi, whether or not there have been any statements on record by the state with respect to the handling of that evidence? Like, did they put any evidence techs on, or has Proctor come out and said, I've never touched that thing? Like, do we know that exists or not?
Not that I've seen. And with everything going on in me the last couple of months, I haven't kept up with anything in the last, or very bare minimal in the last couple of months. But not that I've seen. And that was one of the things that was so interesting to me about this, because, you know, it at that last hearing a few months ago, when the defense brought up, you know, all of these undocumented searches where, you know, he all of a sudden shows up with these, you know, things of evidence. I haven't heard anything since then about any kind of documentation. She called them undocumented searches because there's nothing that shows that he went on those days, who went with him, where any of those pieces of taillight on all these different searches were, found, or how they were handled. There's no chain of command. There's nothing. There's only the dates written on the bags. And I've seen nothing about, nothing contradicting that from them or explaining that in any way since then. So,
okay. Yeah. So, I mean, I think that's fair game. I think in light of, how did the judge leave that? Cause I was trying to get ready to come on. Is that like still pending? Like, was the judge, did she take that under advisement of whether or not they're going to turn over Proctor's profile to them? Do we know?
I believe they're going to, correct me if I'm wrong, y'all in chat who have sharper brains than I do right now. But I believe they said that they not the actual samples, but the profile itself that they'll turn over. If I heard that right, I'm going to have to go back and listen to this when.
Yeah. And so
again,
even with DNA, it's like in my DNA expert I was lucky because he's an Illinois guy. His name's Carl Reich. Like, he's the guy that I go to when I have to, and the guy's brilliant because he can break it down so that lay people, including myself, like understands it, like in terms of like the loci and and you come to understand that is interpretation as well, whether or not there's samples, 2 DNA profiles that are a match. Like they can do like 2 different analysis can look at it and come up with 2 completely different analyses, so like that is very much like DNA is not like phone data, like we're definitive. Like DNA is especially if you have mixed profiles where you've got more than one profile. Because like if you think about the reality, like if you look at my phone, everybody in my family has handled my phone during the course of a day. My kids, Allie, whoever. So there's going to be mixed profiles all over it just from touch DNA. So, and that's going to be the case with anything. So the defense wanting to test, having their own independent test is 100% within the purview of something that they should be able to do. The problem then becomes is whether or not the state's going to turn around and say that all of the DNA was exhausted in our testing, but they're supposed to let, the DNA, whoever's doing the testing for the state, if it's a state lab, is supposed to say, look, if we do this test, if we run it again, we're going to exhaust all the DNA. Are you allowing us to do that? You know what I mean? So like, and it's supposed to be noted in the reports because it's a big deal. It's a big deal for us to not be able to test it, have our own independent test of the DNA because of that situation where 2 different labs can come up with 2 different analysis. So I think that's all fair game, especially in light of what's going on with this case in terms of, the defense's theory of what happened here. I think it has to be fair game. But then, when you look at the fact that she, like, to me, I think it's repugnant. And I don't know if Brian's still in here as a cop, but the fact that they never even stepped foot in that house that night to investigate if something took place. If I had a dead guy on my front lawn, I would 100% think that the cops were coming into my house, especially if there was the premise that he was in the house.
Right. It's not even like he wasn't just in the road and they're going to go into all the houses around.
Jogging by.
He was in the yard and knew them.
It was invited to come there.
Yeah.
Like the fact that they didn't go into that house to me is such a red flag.
Yeah.
Like like that was like, I'm like, how could they not have gone in? How could they not have talked to is Brian Alberts the homeowner? I always get the Alberts mixed
Brian
up.
Albert. Yeah. He's
so Brian, like, how do they not even have a conversation with that guy?
Right.
It's like when you look, oh, hi, buddy. When you look at those things and you hear about stuff like that happening, it makes you wonder what the hell is going on here. Like immediately, that it just wasn't a thorough police investigation. And it makes me suspicious immediately. It's one big holiday, my morning jacket. It's a little brand that Allie and I were pretty heavy duty into. So is there any other questions that I didn't handle? Oh, people keep asking about the brother thing. so I Googled it. Like, 'cause somebody was
Yeah.
at the, like, I wasn't gonna like, I didn't know if it was like, ah, what's up, brother? You know, like that type of thing. Oh yeah, you know. So I Googled it, and I Googled specifically like the use of the word brother or sister attorney in Massachusetts, and it's old timey. Like they use it. They're not saying it like, oh, what's up, bro? They're saying it like, oh, brother attorney, and you know, or sister attorney. It's like powdered wig era type stuff. So
Yeah.
it's common there. I wouldn't say it's common. I think it's probably gone out of favor, but depending on where you're at, and like you were aptly noting, it is a commonwealth. Like we were
Yeah.
licensed. So Allie's a Philly girl. So when I got out of law school, I got licensed in Pennsylvania as well, which is also a commonwealth.
Right.
And it's a different system. You know, it just is like the clerk of court in Pennsylvania is called the prothonotary, which I'm like, what the hell is this? I was like,
Yeah.
proto notary. I'm like, what?
Yeah.
When I first got out of law school. So they are different. I just think it's a term of art that's used in Massachusetts in terms of deference. So I don't think like, because my initial response to that was, I'm like, I would never be that informal in court to call people,
Yeah.
like, oh, what's up, brother? Oh, my
Yeah.
brother attorney. You know, I like, but
Yeah.
when I Googled it, it sounds like it's a term of art that they use there in terms of deference to either opposing counsel, or it could be counsel on, you know, on your side of the table.
Yeah.
You know, it's co-counsel. So that's what
That
I've
was a
done.
new one for me. I had not
Me
heard that
too.
before. So
Me too. I had never heard it either.
yeah.
Let's see. So did anybody else? Oh, you're getting some love, Scout.
Aw.
Let's see. Anybody else throwing up any questions down low?
Especially any more of the legal questions, because y'all know
Yeah,
I'm
like
not
that's my thing.
I'm not the legal question. So anything that's any of the legal stuff would be good to
Thanks,
ask
Tina.
today.
I try to keep it clean. Like I try not to draw. Like I try to kind of stay to S words. Like I try not to. I've got to be really, really worked up to drop a F bomb. Like, and I don't swear very often on my, but I'll drop an S bomb because I don't really consider that like a swear word very much, to be honest with you. Indictment to motion dismiss. So, Michael Breen. So, like the one thing that I did, so it does not appear that they are filing any motions. So it's today we know was the filing deadline for any evidentiary motions, meaning attacks on evidence or evidence that they're seeking to have suppressed or statements that they're seeking to have suppressed. So today's date came and went. So we can anticipate there's not going to be any motions to quash or suppress statements or evidence. Okay. What they did file they said they're going to get a file on the end of business today was a motion to dismiss. So they're going to take another shot at that. And that's not necessarily evidentiary. They're not trying to keep, you know, evidence out of trial. They're trying to get the case booted or one of the counts booted. So that's still coming, but this thing's coming, you know?
Yeah.
Like, are you thinking about, like, early on, I was like, damn, man, I'm going to go to Canton and go sit in on this trial. Are you thinking about doing it?
I don't know. I mean, a lot of it's going to depend on health stuff. I have my next PET scan in March, and you know, this one is scheduled for March 12th. So I don't know that I'll be able to, but I'm definitely going to be streaming it
Sure.
if I can. But it's funny though, because I've had I had a lot of positive feedback with the podcast, and so I had people that live in the area. They're like, you can come stay with us, like, you know, we'll come. And I had like people who own restaurants and stuff, like, we'll feed you, come, you know, come to the trial, and which is so cool. Like
It's super cool.
The locals have been awesome.
When I first went on Turtle Boy's show, you know, I had the same response from a lot of the folks up in that area. They were like, oh yeah, we'll house you. Cause I was like, oh man, I'm coming in for this trial. You know, and it's like, I'd love to go for it. Like, you know, I like to do that boots on the ground. And I know you do too. It's always hilarious. Like I'll be watching something and I'll be seeing you in the audience or in the gallery.
Oh yeah. Like the Adelson trial. Yeah.
Yeah. Or like, and who was the other dude who was at Murdoch? I forget. He's another YouTube guy.
Oh, JLR.
Yes.
JLR. You can see JLR, like, you know.
Yeah. Leading to be on
I
in
saw
frame.
that clip.
Yeah. That was hilarious. So yeah, they're fun to attend, you know, but like depending on how long it lasts, it can be cost prohibitive, you know, where it's tough, like especially, you know, it's like as much as I'd love to stay with somebody that has been kind enough to offer their house up, it would still be like a little weird, you know, like it's, not that they're not amazing people, just like I feel like I was invading their home, and if it goes on for weeks, I'd be like, oh my god, I feel like such a clamor, you know, like we're going 5 weeks in, I'm like, hi mom, you know, just walking in. So
plus, I'll say this, when I'm actually streaming the trial, or watching it at home, I hear more than watching it in person. Like when all during the Adelson trial, I had to go back and listen because there's a lot of things that you miss. And plus you can see me on every time you see me on camera, you see that I'm looking at the jury almost the entire time.
Totally.
So I am watching every single which is how I picked out the juror there were so many problems with during the Adelson trial. But then I have to go back and watch, because then I have to watch, you know, the attorneys and the, you know, witnesses and all of that stuff, but when I'm in person, the only thing I ever really was paying attention to is the jury. So it's an interesting, it's two totally different perspectives, watching it,
different dynamics. Like you're getting the dynamic of trying the case, you know, because like the only thing that matters is the damn jury, which when we're watching the trial, like you said, streaming is an element that we are completely not privy to. So like that's what I'm doing as a defense attorney. If Allison's up cross-examining a witness, I'm sitting there just staring at the jury to see if any of it's resonating, to see if any of it's trying to figure out if any of it's hitting home. You know what I mean? Like that, because they're the 12 that matter. You know what I mean? Like they're the ones deciding the damn thing. So it's a whole different element. And like you just like being inside the court with the trappings of the court, it's just a completely different feeling than watching it streaming. You know, it's like, it's like I love it. I love it. Like as much as I was happy to get out of practicing actively, it's like the one thing that I'll always miss is the trial work. So Scott McGinnis said, even if defense motions are stonewalled by anti-Bev, Alan Jackson got even more on the record regarding Trooper Michael Proctor's clear conflict of interest in the case. I agree. And look, I mean, the fact of the matter is a vast majority of defense motions, like you become accustomed to losing defense motions. You know, it's just like they're hard to win. And unless there's like just an open and obvious constitutional violation where, you know, clearly they should have had a search warrant when they searched and they just didn't. Right. You know, because it all goes back to what we were talking about earlier, where you're talking about like, I don't know when this police report was written. Right. I don't, you know what I mean? So it's like the same thing goes on with searches. Like you don't know, like you have the warrant and you have what their probable cause was at the point that they walked in with the warrant. But, you know, if you've got a warrantless search and then you've got them preparing the reports long after the fact, and that's what I'm getting tendered, because of course I wasn't there during the search, and they're saying we had something in plain view, which if you've got something that gives them probable cause in plain view, they don't have to go and get a warrant. So, you know, it's like all those types of things are always in play, and it's all super interesting. And you know, and it's tough from the defense side of it, you know, because Bob, did someone on your team focus on the jury? Yeah, Rachel, like depending on like who it was, like on Garcia, we had like a much bigger team. It was like, I tried it. Allison was my trial partner on that until they removed her for being too damn good and too aggressive. Like seriously, they were like, oh, this chick has to go. She was like papering them to death. And like, there's a lot of people that feel like that they removed her, you know, that it was like misogynistic type things, which I do not doubt. You know, I mean, Allison's just a very aggressive attorney who is going to like make sure that the state is doing their job and trying the case, and they're going to make sure that it's like beyond a reasonable doubt. So she's the baddest chick on the planet, dude. Yeah. So let me see. Did I answer that question? Oh yeah. So yeah, Rachel, like if Allie was up crossing, like we're always looking at the jury. You're always trying to figure out if they're buying what the state's selling or if they're buying what I'm selling. Now I'm like very personable, you know, like I'm like, I don't come on, like I'm not a stuffed shirt. Even when I'm practicing, I was closer to what I am here, obviously sans any kind of foul language. But like I usually did the closing arguments because I'm personable. And like I felt like I could connect with people, and Allie was like our pit bull opening statement, laying the facts out, laying our what is it, buddy? My dog. So but you're constantly looking at the jury. You're always trying to figure out if you're hitting home or if you're making points, but you still, as much as you think you don't know. You're like, because like especially in a 6-week trial, be like, oh yeah, I think the guy in the back row over to the right, I think he's on our side. Like every time he walks in the room, he looks at us. It's like you're looking at little things like that as attorneys, like to try to figure out if you've got a jury. Like you'll like I'll be like, oh yeah, the woman in the front. Every time I stands up, and get in front of her, she smiles a little bit. So I think she likes me. She thinks, yeah. But it's like you just never know. It's like you never
even
know.
hearing in Charlie Adelson's jail calls, he even pointed out the same juror that I was in here because there was a couple times where Kathy from Gossip Rumor and Innuendo was covering the stream, and I was like live chatting in here, and there were a couple times when Jessica for most of it, Jessica for Justice was streaming. And so I was in chat giving updates on like, this juror's doing this and now this is happening, and I kept telling everybody about this one juror. And I was like, this one's going to be a problem, y'all. Like he is very, very animatedly pro Charlie. And in the jail calls, Charlie mentions that in one of the calls to I think it was his baby mama or something. And he's like, yeah, there was this one juror. And if he would have been on there, he would have been, it would have been a hung jury because he was he would not have voted guilty. And he said he ended up being an alternate. And I was like, okay, well, there you go. Like that's, he saw the same thing we did. He was watching the same thing we were. And then of course it's the same one that contacted the defense after and was like, oh, did you know jurors had a group chat? Okay,
right.
Well, that's not shocking. Like,
Yeah. I mean, it's like, oh my God. So like, what is your take on the whole Becky Hill Murdoch thing? Speaking of group chats, like what? Oh my God. Like that thing. Oh man. I hate to tell you, but like that dude, that turd is getting a new trial. Like they're going to have to spend a fortune to retry that guy and convict him again because like strip away everything. Like the bottom line argument, the state is saying that the law requires the defense to meet the burden that that even if they were tampered with, that the juries that caused the jury's verdict to change. And the defense is saying, no, that's not how it works. Any tampering is cause for a retrial. And the defense is right. Like if you and forget about being defense attorney or anything else. And I know no one wants to hear it. No one wants to have that thing go back for trial, but you can thank Becky Hill for it. Like Becky Hill, like she was off the rails. And the reason is like, you always hear, and Brandi, you've been in there in trials. You always hear that the admonition by the judge, like, hey, I just want you to know, jurors, that if you run into an attorney in the hall or you see them in the bathroom and they don't say anything to you, it's because they can't have any communication with you and they can't even have the appearance of impropriety. It's that serious because it is impossible for a juror to say, okay, I'm going to go back in time to the point where Becky Hill made this statement to me, and I'm going to somehow be able to figure out whether or not what she said to me actually impacted my thought process. Like none of us can do that. You just can't do it. We don't have time machines to go back to 5 minutes before Becky Hill comes in and says, don't believe anything Murdoch said. He's an absolute turd. You know what I mean? And it's like, even if it's true, it's one of those, like, that's why you can't have any communication with the jury. Like it's a super serious rule. It's such a slippery slope. I don't know. That thing's a nightmare. Oh my God.
It's a nightmare. And it's another case like this where like the two sides are so like, there's so much vitriol that comes with it, which can be really frustrating. I said when we first watched that hearing, I was like, I rolled my eyes. I cannot, and I've been very clear about it. I cannot watch Dick and Jim without rolling my eyes. It's going to happen. Like, this is not one of the cases where I'm going to like go into it with, you know, like
Objectively.
yeah, like I've spent, you know, how much time I spent on that case and how much, you
100%.
know, so and then I had somebody trolling me on Facebook saying like, because I said something about, I was like, you know, if there's any bit of tampering at all, yes, he deserves a new trial, because everybody, even shitty people, deserve a fair trial.
Right.
And I was like, he's still guilty, but everybody deserves a trial. And then I got trolled by this one guy who was saying like, you know, screenshotting it and sending it around saying like, this isn't how it works. If he, you know, innocent until proven guilty. I'm like, I've seen the evidence. You know, like getting a new trial doesn't mean that all of a sudden I have to pretend like I haven't seen the evidence. I've seen the evidence and came to my own conclusion. So like, he's to me, there's, you know,
and us as like observers saw more evidence and know of more evidence than the jurors do. You know what I mean? And it's like, you know, the thing that you worry about with a retrial is that both, like, it's an advantage and a disadvantage to both sides. Like both, like Creighton will be able to probably trim out like a vast majority of the financial crime stuff. Like he'll be able to tailor that and say, okay, this is the stuff that really hit home. Like this is this, you know, they'll be able to shorten it in that sense. But at the same point, the defense is also going to know what didn't work for them. You know, like the gray boy, the gray midget, the 5'2" midget dude thing is didn't sit well with people. It didn't work. You know, they're going to be telling Murdoch like, oh, dude, you don't want to testify because that didn't go. Yeah, like no matter how, you know, effusive he is about wanting to testify, they're gonna say, okay, well, if you want to get convicted again, smart guy, then testify. You know, I mean, ultimately it's his decision. So I mean, the trials will be different. The evidence will be the same, but how they're presented will be different.
Yeah.
And in terms of, you know, a new jury, because like we all in the true crime community think that everybody's heard about every case, and it's just not the fact. They'll be able to impanel people that, and I would not be surprised if at this point they do what they should have done the first time, is move for a change of venue. Like at this point, I can't, like, especially with the whole Becky Hill thing. Like I think that they'll have a powerful change of venue motion where they have to get it moved out of that county, because that county's tainted as all hell now. Like there's no way in that county in particular you're going to be able to impanel an impartial jury. I think it would be very tough. You know, where you're finding people that like literally have not heard of the case and more importantly formed an opinion that their mind is not going to be changed. Like you. Like I'd be kicking your ass off the jury in 2 seconds. Brian Churchwell, thank you, and I'm excusing you. I'm like, you know, like there's no change in her mind, you know. So yeah, it'll be, but yeah, what a mess. What a mess.
It is. It's, you know, and oh God, help us all. If there is a new trial, you know, I'll say this, like a lot of the stuff that is, you know, a lot of the papers that I've read, and I haven't read all the new stuff that just came out like a day or so ago, whatever it was yesterday, it's all running together. I've got some stuff I'm going to catch up on this weekend. So I haven't read any of that yet, but of the stuff that I've seen, a lot of it doesn't have anything to do with the trial. So it's like, okay, this is all, you know, like fluff, and okay, yes, they're going after her credibility. But a lot of it is like, I'm like, okay, like swoop that away. None of this has anything to do with it. I'm trying to like look at the stuff that's actually, you know, affects the trial. And to me, I haven't, you know, seen a lot of it there. But the problem is if, you know, and that's why this, you know, these hearings will be this month will be so crazy. Because, you know, there's going to be a lot of stuff that we're going to be hearing, and, you know, and then we'll be able to see like exactly, you know, what is, but oh man, if there's a new trial on that, it's going to be,
oh, man, it's going to be unbelievable. So it's like what's getting argued in front of the Supreme Court, because I know you've been down and out a little bit. Like, so like the issues, like the collateral issues of Becky Hill, like, can we bring in the fact that she plagiarized portions of the book? Can we bring in the fact that her son was doing some pretty naughty things online, you know, that seem to be, you know, like, and those are collateral issues, but the defense is arguing that they're in a case like this, or in a fact pattern like this, when her credibility is at question, that even though the collateral, they have nothing to do with the case itself, they have nothing to do with what she may or may not have said to the jury, that it goes to her credibility. So that's going to be like that preliminary, like, finding by the judge is going to be whether or not they're going to be allowed to bring that stuff up. That's kind of like a motion in limine. Like that's a good example of a motion in limine, like whether or not they're going to be able to bring that up, you know, during the hearing itself. You know, even though the hearing is just in front of a judge and it's not with a jury, you still are always worried about the appellate court. Like, because those rulings, like if they have to go up to the Supreme Court of the United States, if they go the federal route, you know, they're going by the record, and that decision, the decisions that are made by the judges there in South Carolina, that's what's being reviewed. You know what I'm saying? So like they want to try to get it all right. They want to try to follow the law. So like that's why that kind of stuff matters. Like like all decisions by all judges in all motion phases long before trial is all potential appellate issue stuff, you know, like all of it. It's not just trial. It starts at the very beginning of the case, you know, like you're looking at everything all along the way. You know, it's a process. And that's why, like, when people are like, oh my God, there's another continuance, why does it take so damn long? It's like, it's hard to prepare a case to go to trial because there's so many moving parts. There's so much to do. And it's just not as simple as like, oh, I got a bunch of papers. I'm going to go sit at a table. I'm going to argue a position. It's not like that. Like there's so much to do. Like just the mechanics of subpoenaing everybody and making sure that people are going to be available as witnesses and getting all your experts lined up and preparing your cross examinations, preparing your direct examinations, trying to talk to witnesses. It's like, there's so much to do, you know, and it's crazy, but yeah, man, like, oh God, like I'm just telling you, like I'm on record, the dude's getting a retrial. Like I know no one wants to hear, I don't want there to be a retrial. I mean, I'll of course watch it, but like I don't want it to happen. Hope like Rachel, hopefully Creighton also works on his PowerPoint skills. I can't talk too much shit because like I am like a tech turd. I'm getting a little better. I'm a little better. Like I don't have the ability to be able to like, I can't get on and like create a chart like you can. It's so cool. I need to like offline, like have you give me a lesson how I can do like put together some nice like factual charts for stuff that I'm trying to do. Like the other day I did like a timeline on the Natalie Grace. It was very, very bare bones. It was like timeline, no graphics. And like, I'm just, you know, so, but then I did it as a slideshow, which is kind of like blurbs. So yeah, you know, I'm old school. I'm an old guy. So, you know,
well, you know, I went to college for psychology. And so one of the things that was one of the classes that I had that was the most interesting to me was like the psychology behind visual information and how people can interpret it. So when I do my stuff, I'm always like, okay, it's like, what's going to make this the easiest to like break down? But it's so time consuming, but especially like the fact checking and making sure everything's right or whatever. But to me, it's so worth it because it just, to me, it makes me understand it better. It makes
huge. It's like having like, you know, having like a visual aid. What we call in the law game, it's demonstrative evidence. Like when we put those charts together or have nice demonstrative evidence, because you want to make it clear. It's like having it like laid out for us so that it's palatable, so that we can look at it, understand timelines. Like your timelines in Murdoch were everything, dude. Like me being able to reference those and just be like, oh shit, well, boom, boom, boom. Like if I had a question in my head about like what took place at what time, because it's hard to keep track of all that shit.
Yeah.
You know, it really is. It's like you start forgetting, especially when time is so important. Like every minute, every second is so important. To have that laid out for you is massive, you know? And that was always the thing, like with Murdoch, the thing, like when I'd be on court TV and I'm like, man, like they don't let them, like they don't have notepads. You know what I mean? I'm like, how in the world are they, like, how is the jury remembering all this stuff? You know, it like, and you worry about that. Like I would always demand that the jury have notepads. Like you want to see, like, that's how as an attorney, you know, the jury's really engaged in the case when you see them feverishly taking notes, you know, and it's another good indicator for us. If something that we said on cross or a question that we asked, if it hit home, if you see them jotting it down, you know, you're like, oh, all right. I saw them all scribbling feverishly. So, you know, because like if they're just sitting there during a cross and they're not writing anything. You're like, oh man, this is not going well. Like,
Yeah.
they don't feel like they need to remember any of this. Oops.
Yeah.
So it's like, that's another good way to tell if a jury's like engaged in like, feeling what you're picking up, what you're putting down. You know what I mean?
Yeah. Yeah. I get that. It's wild. I follow, like as much as I can. Some things I jump head first, into, and like Karen Reed has been one of those, Murdoch has been one of those, I have those cases where I go all in, but they're so time consuming. But it's like once you're in, there's no, like, you're there, like you live there. That's what.
Dude, believe me, I know that's me with Delphi. Like, I'm boots on the ground in that case. Like, I'm in the court, like every hearing. Like, I'm driving to Delphi because it's only like 2.5 hours, and I'm in, and I'm big on, like, I'm not even talking about the innocent or guilt phase at this point. I'm not talking about the Odin stuff. I'm not talking about the evidence. I'm not speculating whether or not like my opinion on that PCA is it's weak as water, that the state better damn sure have more evidence that he's the guy, because based on that PCA, I think it's weak. That's just my opinion on it. Does that mean that at trial, if they have strong evidence, that I don't think that he's going to be guilty? No, not at all. Like, my opinion 100% could change on that. What I am concerned with is that she removed his choice of counsel. I'm concerned with the constitutionality of it. That's what my issue is. Like, that's all I've been covering. Like, I'm driving. I'm going to go to the Supreme Court arguments. I'm going to get my ass up at the crack of dawn, get in line, and I fully intend to be sitting in that courtroom. And I'm hoping somebody will help Allie figure out how to stream it on our channel, because I want her to be able to kind of talk our viewers through a Supreme Court hearing. They're very different. Like, people are going to be like if people are streaming that, and people are going to be like, because like Supreme Court justices, when they're sitting up there, they interrupt the lawyers all the time. It's very different than any other hearing you've seen. Like, the lawyer will be in the middle of saying something, and one of the jurists will say, one of the judges will be like, oh, like they'll interrupt them and they'll ask a question. And it's like a ton of back and forth. It's a very, very different proceeding. They're fascinating. If you guys have never watched like a Supreme Court hearing or appellate court hearing, watch it, because they're really fascinating. And in that case, the issue is boiling down to whether or not Judge Gull, who was the sitting judge in that case, had the ability to remove them from the case when they were his counsel of choice, meaning that. And the issue is that those attorneys were appointed as public defenders initially. In the law, as it sits right now, is that like, people that are appointed public defenders can't say, oh, I hate this guy, I want a new one. Oh, I hate this chick, I want a new one. Like, you can't just pick and choose. You're kind of stuck with them. But what happened in that case is she forced them to withdraw by saying, I'm going to publicly shame you because I've found you to be grossly negligent, without the benefit of having a hearing on it, just believing whatever the state has said. And she basically says, so either I'm not allowing you to prepare a defense on this in terms of, because there was a leak, and she put together like 5 or 6 things that she thought were grossly negligent about the representation of them. So either I'm going to shame you publicly, because this is the one time I've allowed cameras in. So it was all set up for these guys to come in, or you can just withdraw from the case. So like, one of them said, okay, I'll orally withdraw now. And the other one's like, I'm going to think about it, and I'll put something in writing. So at that point, she considered them withdrawn. They then turned around and filed their own pro bono appearances in the case, which was a huge move. Like, the argument from the pro prosecution is like, oh, that was just like, there's no way they would handle that case for free. It's like, it's a practice killer. When you have a case like that, that's the only thing you're working on. You can't work on other cases. You're not taking on new business because you can't give the attention that you need to give to your other clients or prospective clients, because, so like, it would destroy your practice. All your business would dry up, and in private practice, that's your bread and butter. I mean, defense work is a grind. Like, you're taking on DUIs, little theft cases, like all that stuff. It's like, like defense work from the criminal defense side of it is not like money making. Like, you don't get cases where you have exceptionally wealthy clients very often. That usually falls in the white collar crime area, where you have white collar cases, murder cases, like where people are typically broke, or just like average Americans that don't have $500,000 to pay a lawyer to come try the case for them. These cases are rare, so you're out there grinding. trying to make a living, trying to support your family. And it's like, it's just, yeah, that case is crazy. So yeah, like if y'all have not been following that Delphi thing, fix your life. Follow it. It's a crazy case. It really
Yeah.
is. It's like, it's
I've
got,
had so many people ask me to do a chart on that one, and I'm like, it's so crazy. I don't have time to like invest in another, because that's another one that
girl,
it's so
you don't like it because and then because if you did, you'd get sucked in, and
Yeah.
it's like the biggest rabbit hole of them all. And if
Yeah.
you get into like the toxicity of the online world with that case is beyond anything that I've seen. Because remember, that case was cold for 5 years
Right.
with an entire Reddit community speculating, thinking it was this Keegan Kline guy or the Ron Logan guy who owned the property where the girls were thought. Like, so for years, people were, just had theories on that thing, and people are just like locked in on their positions. And like many people that just convict people on PCAs, like our friend Jennifer Coffindaffer always does, like they're locked in. Like, Richard Allen's guilty. Like, he's the guy. They arrested him. How can he be guilty? And I'm like, oh my God, dude. Like,
Yeah.
So it's like, but that thing is such a rabbit hole. And then there's no way. I wouldn't even let you do it. I'd be texting you, don't do it.
Yeah.
Don't dip your toes in. Like, you'll get sucked in. And it's too
Yeah.
much. It's too much. Yeah.
It is.
Yeah. It's like you got your flake, like, because when you decided to get into this, I remember we were messaging each other. I'm like, girl, I'm like, beware. It's a massive rabbit hole, and,
Yeah.
and it is. This case is that. And plus you're covering trials that you cover, which you're
Yeah.
digging into those too. So you got a lot on your plate, and it's hard. Like, it's the same as me. It's like, people are like always complaining, like, why don't you finish the Garcia case, which is my second season of my podcast, which is the case that we tried. And I'm 48 episodes in. I want you to try to, and I am a deep diver, girl. So I just
Yeah.
want you to try to wrap your mind around that. Like, my seasons, I don't follow the rules. Like, most seasons are, 8, 10, 12 episodes. Like my Gacy season was 36. Garcia's 48, and I haven't even got to trial yet. It's like, it's a lot. So I'm in the same place that you are. So you kind of have to pick your poison, and it's like, but you're like so interested in stuff that you hear about that you want to dig in, just because it's our nature of wanting to know, so it's hard to pick and choose, So Tina asked my thought on Karen Reed's judge. I mean, it's par for the course. It's like I get it. Like I thought that there was a valid argument for recusal, maybe. Like they were trying to say that she was biased, and they were trying to show, like, at the end of the day, that's her decision. Unless they can show true bias to where they get that hearing in front of an independent judge, like, it's going to be her decision whether or not she's going to recuse herself. And if she's going to sit on the bench and say, no, I'm not biased. Like, people don't understand that we lose as a defense bar in general 90% of our motions. Like, we just don't win them often, because most of the time the cops do the jobs right. If the cops do their jobs well, we're not winning a motion to suppress. If they follow the law, if they have the probable cause, if they've done the work, they're not going to lose the motion because they follow the law, and the judges aren't trying to throw evidence out. There's got to be like a flagrant violation of the constitutional right for a judge to say, my hands are tied. Like, no judge wants to throw away a key piece of evidence in a case against somebody. But, if it's so evident that the cops violated the Constitution, they have no choice but to do it, So, like, I just, you just hope, because ultimately her role, because it's a jury trial, is she is the gatekeeper of the evidence. And you hope that she's fair about it. And like, I think I've disagreed with some of her rulings. Like, I disagreed that she wouldn't allow for them to get Albert's or Brian Albert, his phone records. I think they absolutely had a right to get that. They can't help, the defense can't help that the cops didn't investigate them at all. Like her pretending, like what we talked about earlier, that the fact that the cops didn't go into that house is absurd. Her ignoring that fact just as a rational human being is bizarre to me. Like as a judge, like if I was sitting on the bench, I'd be like, well, here's the thing, state. I could see a world in which we have to turn over his records because it's my belief that the officers should have gone into that house knowing the fact that the allegations are that he was invited to that home to come inside for a party. I think that issue of whether or not he came in is in dispute. And I think that potential evidence is relevant potentially. And like, and if we're in the search for truth, which is where people just are always like, if we're like, it's the sad thing about our system. It's like the truth and justice are two completely different things sometimes.
Right.
And, you know, and it's like it's so frustrating from the defense side of it. And I'm like, are we trying to get to the truth here? And, you know, and when I question a judge on it, they get super pissed. Like, you know what I mean? They get really upset. Like, are you questioning my integrity? And I'm like, no, I'm not. But I think you're missing the bigger point, you know. And it's like, so I got to toe the line. Oh, Kaylin's in the house. What's up, girl? Yeah, I saw. She said she had to take a break from like absolutely flame throwing everybody. Do you follow her Twitter account, Kaylin?
Okay. Oh yeah.
Oh God, it's the best. It's like I always put my favorite meme is I don't know if it's an emu or like a llama. It's like an emu. It's a cute little like deer-like creature eating popcorn. Like so every time Kaylin's like flame throwing some pedophile who's decided to talk shit. Like it's unbelievable to me that somebody who's got like active like pedo cases, like child porn cases, decides to like, and I'll always like type a little warning on there. And like most of her followers will be like, all right, well, you might want to take a step back here because she's about to flame throw you.
Yeah.
Oh, I'll give you some cash. Yeah. All right, let me run, y'all. I gotta handle some business on my end. Brandi, I love you.
Love you too. Thank you so much for coming on with us. I know it's last minute.
Feel better. Get some rest.
Thank you.
Thank you for struggle busing through it with us today. We appreciate you. And because this is where I came. I wanted to watch it with you, so I'm glad. And thank you for having me on. And thank you everybody in the comments for being with us. And thank you for all the kind comments. I really appreciate it. And check out our YouTube. That's Defense Diaries podcast. That's our YouTube channel and my podcast. More importantly, this guy, Defense Diaries.
Great podcast. It's the link tree's pinned at the top of the chat. So y'all
awesome. All right, y'all have a wonderful
Thank you,
weekend.
Bob.
Get better this weekend. Rest, relax, take care of yourself. Okay.
Thank you. I will.
All right.
Bye. Oh, we love Bob. I appreciate hearing the legal. Oh, hi, RA. Hello, recovery addict. I appreciate hearing the legal aspect of things because as much as I love, you know, going through evidence and getting like whole picture stuff, hearing the legal side of it is always, you know, really interesting to me. And he gets to answer all of our legal questions. And we follow a lot of the same trials and get to debate back and forth with evidence. So that's cool. So, so we appreciate him. RA, are you not live anymore? Oh, you're at lunch. I was going to try to send everybody to you when we finish. But yeah, Bob is great. The link tree up at the top is pinned. I send people to his podcast. He does a great job with the Steve Avery stuff too. If you've the Making a Murderer documentary, lunchtime. I got my lunch right here too, like ready for me to. I will tell you, I have an addiction to cuties, like these little, I will eat like nobody can eat just one. These are like, what did they say that like some kind of potato chips or something? It's these, like I have to eat 2 of them at a time every time. They're so like, or sometimes 3, whatever. Don't judge me. These little cuties, best thing out there. All right. Did we get through everything? I think we did. The plan for today. Oh, Lay's chips. Yeah. See, y'all know. Y'all know. Even the things I can't remember, y'all remember. The stream that we had planned for today for the stuff for the trial that we're starting next week. The trial was originally supposed to start Monday. So we were going to watch some of the, like finish watching some of the stuff and do the intro stuff today. But the trial has now been delayed till Thursday. So instead of doing that today, I'm going to try to get a little bit more rest. I have not been feeling well at all. So I'm going to try to get a little bit more rest today. I have been working really hard on an introductory video that I'm putting together with a lot of the information, a ton of pictures, to kind of get us into this. It's a crazy trial. There's a lot of twists and turns. It's been very high profile. So I have put a ton of work into getting a video done for it. And so I'd said yesterday that I'm going to schedule it when I finish it. I'll try to finish it over the weekend. I'm going to schedule it like as a premiere on YouTube, and so that way the live chat will be going as it's playing, and we can all watch it together. But it's I know I keep saying it, but I'm with everything going on health-wise, my brain is not as sharp as it normally is right now. So I've figured I'm going to do this as a video, and then that way I can make sure I don't miss anything, because I'll have time to go over everything and double check it. Like even earlier, I called somebody the wrong name or something. I don't know. So I'm in order to make sure that we get all of the right facts, I'm going to do it as a video, and we'll just watch it together. So that's the plan for I think, if the trial is going to be Thursday, we might do that on Tuesday or Wednesday. I think Monday we're going to keep it kind of informal and watch some of the previous hearings and that type thing. We'll kind of play it by ear, but we're definitely going to do a stream Monday. I think I have it scheduled to start at 12 because I'm supposed to finally hopefully get back to the regular treatment schedule on Monday. So we'll see. I'm kind of play it by ear. I'm going to find out more this afternoon. And I will keep y'all posted, and I will get to working on, I gotta get finished on the Karen Reed stuff, because that trial's coming up. We've only got about 2 months until it's here. So the trial is starting next week. I will show you. Let me show you. I'll give you like a little Cliff's Notes version before we go. It's a y'all. It's a doozy. I'm really excited about it, and I've spent days and days and days and days and days, and hours and hours and hours, researching this one to get it all together. Let me pull it up. I'll give you a little intro to it. The more here it is. More kind of deep dive intro will be on the video, but I'll just give you like a little explanation as to what we're doing. All right, here we go. Oh, let me move that. I changed my screen. All right, so Michelle Troconis is the defendant, and this is starting on Thursday. It was originally supposed to do Monday. Now they're going to do Thursday. So basically, this is the defendant. This is the defendant's former boyfriend, and this is the victim. And you can see I've got like a little video stuff, but basically, Jennifer Dulos was isn't she beautiful? She's very, privileged childhood, born into wealth. Her aunt is Liz Claiborne. Her dad was a really successful, like, New York banker. Super smart cookie. She went to Brown and NYU. Great woman. This is her husband, who his name is Fotis. She met him at Brown. They were just friends. They ran into each other again later in life, got married, and he turned out to be not the guy that she was hoping for him to be. He just ended up, and in the video too, it's going to mention like a law that was even passed because of his like coercive control and stuff like that. He ended up being very controlling, verbally abusive, and like there was some physical stuff, that anyway, we'll get into all the details. He was not a good dude. They were very wealthy. Her family was very wealthy. They helped out. They lived in this ginormous mansion in Farmington, Connecticut. They had 5 beautiful children, 2 sets of twins, and then another daughter. Their marriage started to deteriorate a little bit. They started having a lot of problems. She filed for divorce. When she filed for divorce, in the divorce papers, she said that she knew that he was having an affair. He was a professional or like world class professional. I guess they don't call him professional. What do they call him? Competitive skier or whatever. And he was raising his kids to be, training them to be skiers too. And he had taken them on a trip to Miami to compete in a ski competition. And he met his mistress at that time. This is the mistress who is our defendant. So in the divorce filings, she said that they had been having an affair for about a year. So she moves out. He moves the mistress right on into the family home, with her daughter, one big happy family in the family home. This is just talking about her father passed away, and her mother sued Fotis for a lot of money that he owed them. That the way that he kind of got his business off the ground is Jennifer's parents would like front the money for him to buy the land and build these huge mansions, which he would then sell, and he would pay them back. And then he's like just didn't pay them back some and didn't pay them back on some of the money he owed. So they had been separated, going through a crazy, terrible, horrible divorce, like just hundreds of court filings, hundreds of motions, like just all kinds of stuff. It was really bad. She had filed a motion for emergency custody, physical custody, because she was scared of him, that type thing. The video will go into more detail about it, but it was really bad. And then on May 24th, the Friday before Memorial Day, she dropped the kids off at school. Her plan was to go home, get ready, and then she had a doctor's appointment for herself at 11 a.m. in New York City, and then an orthodontist appointment for her kids at 1 o'clock in New York City. So the kids were getting out early for the holiday. She's supposed to go back and go to her appointment and then pick them up, take them to their appointment, and she never showed up for either appointment. Police, her friends call and report her missing. Police do a big search. They find her car almost immediately in a park about 3 miles from her house, but she wasn't in it. I think that's as far as I got with the picture stuff. I think everything else is kind of still really messy. Like I said, this is like a work in progress thing. But anyway, so they do a search. They don't find her anywhere in this park, but they go to her house and they see what it looks like to be blood type material in the garage. So they do the presumptive testing. It turns out positive. And it looks like there had been an attempt made to look like they were trying to clean it up. So then of course, instead of, just it being a, missing person, where could she have gone? It takes like a little bit of a darker turn. So anyway, they end up linking some of the blood to Fotis, the husband. They're able to, he comes in to talk to police. They do a download of his phone, and based on his phone location, they're able to see that he was driving around Hartford, Connecticut. Now, this is the map that shows. Now, this is where her house was. This is where she went missing from. This is where he and the mistress lived, and this is where they found him driving around. So you can see it wasn't anywhere near where she lives. And they ended up, based on his location, I I give a little bit of information about this thing too. This place, I did some research on this place, and it's really cool. They have it's this huge like kind of command center of all the high tech you know how to like they have the you can tell how exhausted I am. I can't even form words. Like they have all of the high definition cameras, plus like the shot spotters, plus the they have people like monitoring social media for like threats and stuff. Stuff. This is all like this big high tech, crime busting center, which is really cool. But based on his cell phone location evidence, they go to, they partner with this command center. They get all of this video footage. And so they're following his route along where his cell phone is showing he's going. And he's going to all of these trash cans. There's 30 trash cans total that he goes to, and he's dumping black trash bags in them. So they go get the black trash bags, and they end up finding like, zip tie, like used zip ties that had blood on them, ponchos covered in blood, like cleaning supplies that had her blood. And all of these have her blood and stuff on them. And then they also have, one of the things tested also had Fotis's DNA, and there was something that had Michelle, our defendant, had her DNA. They also find, this is the storm grate. They find a photo that shows him shoving a FedEx box into like the storm grate, and they find that, and it's license plate that was registered to cars that he had owned, but he had used tape to like change the look of it so that like if you're just driving by or it's caught on a camera, it looks like a different number than it really was. So they're arrested for tampering with evidence. Isn't she beautiful? I think she's just stunningly beautiful. They also use cameras. They find on a school bus camera, of all things, they find the video surveillance shows a Toyota Tacoma parked around, like right by where her car was found. When they had done some research into this, they pulled the records of all of the cars that were registered to like Fotis and who worked for him, and one of those was a red Toyota Tacoma. So they start looking into that. It turns out Fotis, they have video footage of him too, where he's taking this Toyota Tacoma after this happens and dropping it off at a car place to be detailed. He paid with cash, so they pull his cash stuff and they see him getting cash out of the ATM. And then, like around the same time that before it happened, and then paying with cash. So he's arrested. Oh yeah, I forgot about this. This is a whole nother big twist. This is his friend who was a former attorney of his, not for the criminal case. This is for something else. But he ends up getting arrested for conspiracy to commit murder on the same day that Michelle and Fotis get arrested. It turns out that he is he had there's so much with him. He had owned this property that had like where he founded a hunting club, and he went to the hunting club, and there was like his location data showed that he had gone to this hunting club at some point, and hunters had found described as like a shallow grave, and it had a blue tarp, and it had like lime in it, like that deteriorates the bodies. There was no body, and they did a search, and it looked like nobody had ever been there. But obviously, that's a very damning thing to have on property when you're connected to this case. And he was with Fotis, earlier in when this was going on. So he was arrested too. This was his attorney. He's another character. I'm going to save that. I want to save some of that. Ask Kaylin about it. I want to save some of that. But so anyway, he gets arrested. It turns into like a big, shit show. He ends up getting bond though. And he gets bonded out in like early January. He's supposed to have his next hearing is supposed to be in February, but they end up wanting to do like an emergency hearing because he had been violating some of the terms of his, the terms of his like house arrest or whatever it was. And so the emergency bond hearing is basically like, he knows he's going to get locked up. So the day that he's supposed to go in for the emergency bond hearing and go, basically go back to jail for all of this stuff, he didn't show up. And his new girlfriend, because at this point, Michelle and he have broken up. They're not allowed to have contact with each other after, getting arrested. So they can't have contact with each other anymore. So now he has another girl and he moves her in, and she drove separate. The attorney calls her and is like, hey, where's he at? He's not here. She didn't realize he wasn't there. They check his GPS and it shows that he's still at home. So they go, and he's in his garage. He had hooked up a hose, a vacuum hose, to off himself with carbon monoxide poisoning. And he left a note saying something about how he just couldn't stand to be in jail for one more day for something he didn't do. This is the defendant when they're doing an interview with her, and she says that she didn't have anything to do with it. She said the reason her DNA was on, something in there was because there was coffee that was spilt, and that, she was just cleaning up coffee. That wasn't because she was cleaning up, blood or helping dispose of anything. So, yeah, that's it. That's the trial that we have starting. But the video, it goes into a lot more detail and gets a lot wilder. But it's Michelle Troconis is the defendant, but justice for Jennifer Dulos. I can't imagine having, like how hard things are on those 5 kids. So it's sad. So hopefully this will be. This has been a long time coming. So. The kids are living with her mom in New York City, like Upper East End. So he actually even tried to get custody of them after she went missing, and because they ended up going to her mom's, and he tried to get custody then too. Because at the time when she went missing, he was only allowed supervised visits. Because of court stuff, and that gets really messy and really detailed, but that's all going to be in the video too. But he was only allowed supervised visits, and even his phone calls, he was only allowed to have phone calls like that were monitored on speakerphone. So that's he I guess he thought like, oh, well, I was dangerous for them before, but according to the courts, but now that their mom is missing, I'm not dangerous anymore. So he tried to get custody of them after she went missing, and they stayed with her mom. So, it's a crazy one, but it'll be an interesting one. I put a lot of work into this video so that we can have, because it's kind of, it's so complicated and there's so much to it. So I put a lot of work into going over everything, and there's some false information out there. So I wanted to make sure that we had all the right information. Yeah, they said that they had to get more they had to do jury selection again for a few days because they were down to 2 alternates. And this is supposed to be a pretty long trial. It's going to go through March. So it's going to be crazy. We have some hearings in between now and then. I'm still going to cover the Murdaugh hearings. I can't not cover those. We have a few other things, like there's a couple like shorter hearings that we're going to do, like that'll be pretty much in and out, like the one today was. So we're still going to do those, but this will be this is on our agenda for pretty much until March. By the time we finish with this one, Karen Reed will be starting. So we've got a couple busy months coming up, which is good. It just means we get to spend more time together. So that's what we got going on. I'm excited though. I'm actually excited for the video. To watch it as a as a premiere. I think that'll be nice. All right, so let me see. We're going to wrap it up for today. Let me see if I can. Ari's coming back from lunch, right? Or is he still in here? Let me see if I can portal. I love a good portal. We need to lay down. Okay, he's going to be coming back. I'm going to portal us over there. Save. Okay. All right, I've got that set up. So I'm going to rest for a bit. And then I'll get that video finished this weekend too. Was there something else that we were supposed to? Why do I have a feeling that we're forgetting something? Where's my calendar? Let's see. What else we got going on? Oh, Tuesday at 2:30, Donna Adelson has a hearing, so we'll cover that on Tuesday. So maybe we'll do the video premiere on Wednesday. Let's plan on that. We'll do the video premiere on Wednesday. And then Monday and Tuesday, we'll do a little bit more of these, like a little bit shorter streams, just to kind of get some more information going before we get going. Now, with this one being a longer trial, I wanted to cover the Black Swan trial, but it's going to be at the end of this month unless it gets delayed again. So we won't be able to cover that one with this one. But that's okay. And what else do we have going on? Let's see. Karen Reed starts March 12th. Vallow is supposed to start April 4th, but I have to check into that. I think I remember seeing that it was getting delayed or something. So I'm going to have to check and see on that. But so we got a busy couple months coming up, y'all. Oh gosh. And Murdoch. We're going to be covering the Murdoch trial, the hearings. There's one on the 16th and there's one on the 29th, 30th, 31st, I think. So we're going to cover those. So we'll have to do, I will probably split it up and do like speed trial it a little bit after the Murdoch stuff. You know how we do when we have two things going on, but we will definitely cover those. We'll probably do the Murdoch Live and then do this one, like catch up on it after the Murdoch stuff ends. So that we'll have 3 days of being crazy, crazy busy. But other than that, we'll be good. All right, y'all, I'm going to portal us over to RA, and y'all can keep this party going. I am going to get some rest, and I appreciate y'all. I will post on here when I know exactly what time. I'll set up the stream when I know what time we're going to do everything next week. The only thing I know for sure right now is on Monday, I have the stream set up for 12 Central. So if that changes, I will change the time on there. But right now, that's the plan. So unless there's any other breaking news, I probably won't see y'all again until Monday, unless I see you in chats around these true crime streets. So I appreciate everything. Thank you so much for hanging out with me. If you haven't hit subscribe or like, please do that. We've actually, speaking of which, we're getting close to 15,000, y'all. Let's see. We're at 14,300. We only need 700 more to get to 15,000. That's crazy, right? It wasn't long ago that we just hit 10. So that's kind of cool, right? I think it's cool. All right, y'all. I appreciate. Oh, you want to say bye? She's reaching up on me. You want to say bye to your friends? Say bye. She's getting a haircut this weekend too. She looks a little shaggy. Say, don't judge me. I'm shaggy. It's okay. It's okay. It's big yawns. Big yawns. All right, y'all. I appreciate you. I love y'all. I'll see you Monday.